On the record. This is case number 2012-00520, Kentucky American Water Company. It's filed a application for a rate adjustment. In its application, they propose to have rates that would generate an annual revenues for $12,317,702 and approximately 14%. What is 14.64%. Welcome, everyone. My name is Dave Armstrong, and with me this morning is the Vice Chairman, Jim Gardner, and also with me this morning is Commissioner Linda Breathitt. For the applicant, Lindsay Ingram and Monica Braun.
Yes, Your Honor. Good morning.
And Iris, good morning.
Good morning, Chairman. Iris Skidmore for Community Action Council for Lexington, Fayette, Urban, Harrison, and Nicholas counties.
Welcome.
Good morning, Your Honor. David Barbary and Janet Graham for the Lexington Fayette Urban County Government.
General.
Good morning, Mr. Chairman. David Spinard on behalf of the Attorney General Jack Conway, Jennifer Hans, Dennis G. Howard II, Assistant Attorney Generals as well. Michael Gerberow is a law clerk who's working with us this summer, and he'll be helping us today as well.
Welcome, one and all. Thank you. Other interveners? Other interveners? Jackie, you're not an intervener, are you?
That's Skidmore.
Yes, thank you.
Your Honor, on behalf of Commission staff, Gerald Woocher and Jonathan Byer.
Welcome. Has public notice been filed?
Yes, sir. Public notice was filed on May 31st and is in the record.
Thank you. Are there any outstanding motions?
Your Honor, there are several confidentiality motions that have yet to be addressed. The parties and Commission staff discussed those at the pre-hearing conference that was held last week, and there is an agreement to, where possible, to avoid the discussion of confidential material, but those are still pending. Those are the only. There is another outstanding motion addressing a clarification of a response to the company's response to a Commission staff data request.
And those are all our motions, Your Honor, but we don't see any need for any further discussion because those have been submitted for a while and they can stand submitted on the written record. It's fine with us.
In all of our hearings, in particular the rate hearings, we have a open mic for public comment. And at this time, seeing the number of people here, I will allow each commenter 3 minutes for their statements. And if you need more, I'll give you a little bit more. So welcome any other comments at this time. Mr. Marshall.
Thank you, Mr. Chairman, and good morning, Commissioners. My name is Tom Marshall. I am here as a citizen only today to make my comments and not representing any party. Why am I here? I've been following the string of Kentucky American cases since the application in 2007. I have a few notes here, trying to stay within your 3 minutes. I may go over a little bit.
That's fine.
I'm both here as a concerned citizen and I've also followed it since I bought some shares of Kentucky American and have been able to watch the company and how well it's done. My stock has doubled and I've gotten some nice dividends. The mayor of Lexington the other day said there have been some bad business decisions. Well, there may have been some bad decisions, but I would offer that this is a brilliant business plan. It brings value to the shareholder, and that is Kentucky American and American Water's job, is to bring value to the shareholder. And I think that you will find, if you look at this, that that's their guiding light. That is the guiding light I would offer for any private monopoly utility company. And that is the reason that we have public utility commissions. It is your job to protect the public, to have a full inquiry as to the applications for rates, construction, and whatever else may come along from these monopolies that are trying to do what they see as their job. You must be aggressive but fair in your investigations of these private monopolies. You must not accept the company's statements on their face, but analyze and test their assertions. That may mean that the hearings need to go a little longer when you have these large private monopolies. I urge you not to be afraid to have them go a little longer, or to suspend so that your staff or you can consider what's been said and have the appropriate questions and get the important information into the record. You need to compare the statements they've made. I noticed just yesterday there was a report on WEKU by Stu Johnson in which he quotes the president of Kentucky American as saying, as regards this billing issue that you know about, where Kentucky American no longer is providing billing services for the city. She defended the move by saying the old billing arrangement confused customers. I think you should look at the record and see if that's the explanation that they have given you as to the reason. You should look at the records that they filed in many other states where they have done the same thing to see what that explanation has been. They have filed cases in neighboring states such as Indiana, Missouri, and many other jurisdictions. As to the issue of declining demand, which is a huge issue in the water area right now, she's quoted as saying water use on a per customer basis is declining, but as you have growth in the community and as we're starting to see growth pick back up, we've gone back and looked at the projections that were done before the plant was built, and we determined the size needed for this plant, and those projections are holding true. Frankly, I'm not sure that's correct. I think that you should investigate on behalf of the citizens of the Commonwealth to see if that statement is correct. It is an essential element that you need to investigate. As you're looking at their statements, look at what they have filed in the other jurisdictions. The one that I find most interesting is the testimony that was filed by Gary Naumick, who I believe is the chief engineer for American Water Company out of New Jersey, the parent company. He has appeared in numerous jurisdictions to testify on declining demand and the need for commissions to recognize declining demand. And if I can flip to his testimony from Indiana. And I have some copies of his full testimony. Some of the participants might want to look at it and perhaps even offer it into the record. At page 9 it says, are there benefits from, this is the usual give and take when you have pre-filed testimony. The question to Naumick is, are there benefits from reduced water usage by residential customers? Yes, there are environmental and operational benefits from lower water usage by residential customers. And he goes on with others, which I will not enumerate here because of the time. But then he goes on to say, reduced water usage by residential customers also reduces energy consumption within the consumer's home, etc. In systems where demand is approaching the capacity of water supplies or treatment facilities, the water saved through efficient use by customers can be a preferred alternative to a supply-side expansion with a resulting lower cost to customers. we have had in Central Kentucky a huge supply side expansion. What has that meant for the consumer? It certainly hasn't meant lower cost for our consumers. And in the next sentence, he says, currently there is an economic disincentive to Indiana American to sell less water in our service territories. So I think you see there that that's part of the business plan, at least from my perspective, that if you have a huge supply like this, you want to sell as much as that as possible, of course. You're not interested perhaps in as much conservation as you might be otherwise if you were truly trying to address the issues of water demand and peak demand through conservation. And those are huge issues that this commission has to wrestle with, perhaps in another case, in terms of what's being done about peak demand and how to address it. I could go on for a long time, and you don't want to hear it all. I guess I have to save that for something else. But I know one of the elements in here is what to do about the pipeline that's being constructed from the Owenton plant to Owenton and the decommissioning of the plant in Owenton. Who is to pay for that? Well, I mean, should it be the current ratepayers? Should it be the ratepayers who are receiving the benefit from this new plant and who are receiving very large payments into their tax base from Kentucky Americans since the plant is built in Owen County? Or should it be the shareholders? You know, there's a lot of discussion in the literature and among utility attorneys about the regulatory compact. Well, the regulatory compact isn't that you get to do whatever you want to do as a utility and your costs are going to be covered and you're going to get a return on equity. The regulatory compact is that those things that you do that are reasonable, that consistently are found to be reasonable, will be considered for some compensation and return on your investment. I think you will find in the literature that there is support for saying, no, there are times when you take risks that you shouldn't have taken. There are times that you made bad business decisions. Was the acquisition of this plant in Owenton a bad business decision? Was it based on something other than good business? If it wasn't a good business decision, and it may have had other reasons for its acquisition, and I don't know that to be a fact, but you need to look into that, then I would argue that you should not offer compensation to Kentucky American for that bad business decision. Even though I'm a shareholder, I would say that risk falls on the shareholder. It falls on those in charge in New Jersey. It falls on those who work for the corporation. So if that is the case, then let's see that the customers, that the consumers are not the ones who are always dinged for the cost. Let's share some of this responsibility. Let's go ahead and buck that over to the shareholders. You have a very important task. It's a difficult task. I appreciate your listening to me this morning. Thank you very much.
Thank you, Mr. Marshall. You have a copy of your remarks. I'll allow those into the record here.
I don't have a copy of the remarks. I can certainly provide them through the internet to you, or I assume you've got those. But what I do have is a copy of Mr. Nomick's testimony in Indiana. I would gladly leave that for whoever wants to use it or however it might be.
I'm not going to allow that.
Okay.
But I think you've got all your words down.
Okay.
Thank you very much. Other members of the public wishing to be heard? There appears to be no other members of the public here wanting to speak this morning. Mr. Ingram, your first witness.
Yes, Your Honor. Our first witness is David Baker. He did not file any written testimony in this case. He was involved in some email exchanges about one of the issues in this case, and Commission staff at the informal conference asked if we could have David Baker available to answer some questions. He is one that's agreed to testify by telephone from his offices in New Jersey.
Before you contact Mr. Baker, I believe there are two additional preliminary issues that are required by the procedural order. One is regarding there are several witnesses who have filed written testimony, but who the parties have agreed to excuse and to whom the parties have agreed that their written testimony and responses to information requests that they sponsored should be made part of a record. And according to the procedural order, the parties are required to identify those witnesses, and then there's an opportunity for any person who objects to that. And then I think second, Mr. Ingram is correct. There are scheduled to be 3 witnesses who were originally to appear by video conferencing, and because of technical difficulties, some on the part of a witness, or at least on one witness, but also more substantially some technical problems that the Commission has experienced with its video conferencing facilities and interfacing that with a video record, there are 3 witnesses who will need to appear by telephone. The Commission's order allows for that, but it also provides that any objections be made prior to the Commission taking that evidence. So with that in mind, I would recommend to the Commission that the parties that are sponsoring witnesses who are not going to appear, but whose written testimony is going to be made part of a record, identify those witnesses so that any objections could be made to that, and then the Commission take any objections to the use of telephonic testimony.
Certainly, Your Honor. And for Kentucky American, there are 2 witnesses that we expect to appear by telephone. And the first one is Mr. Baker, the gentleman I just mentioned, who has not filed any testimony in this case. He's just involved in some email exchanges that Commission staff apparently has some questions about. And he is first on our list. The other individual who we expect to call by telephone is the number 4 witness on the Kentucky American list, and that's Paul Herbert, who is in Pennsylvania, and he's our cost of service witness. And he's, I think, watching the webcast and will be available by phone as soon as we get to him whenever that occurs.
Mr. Chairman, the Attorney General and the Lexington Fayette Urban County Government are co-sponsoring 3 witnesses. Mr. Brian Kelkick will be participating by telephone. Dr. J. Randall Wooldridge is a witness that the parties have agreed to excuse from the hearing, but will be subject to answering any questions that the Commission may have. And then Mr. Stephen M. Rackers is a witness who is here with us today. He will be testifying live.
Very well. Ms. Goodmore?
Your Honor, I would just like to state an objection for the record. When I told the parties that I would be cross-examining Mr. Herbert and Mr. Calkett,
Yes, ma'am.
I told them that I would agree to the video conference to be accommodating, because I realized that we're the only party that would be asking questions, and it would save money and time for the parties. So we would not have objected to that. I did not know it would be by telephone, and obviously that's just through technical difficulties, and I understand that. But I also don't believe that's the best way to cross-examine a witness. And I guess our position is if you sponsor testimony, those people should be available at least by teleconference. So while we will go ahead and ask the questions by telephone, I do just want to state for the record that I don't think that's really the best way to do it. I appreciate everybody's attempts to try to make this work, and it didn't work. So, there's certainly it's no one's fault, and I just want to make that clear.
Well, the Commission would agree with you, but we're going to allow the telephonic testimony to be not the best, but at least they're here in voice. So we will allow you to proceed.
Okay, and may I add one more thing? When Mr. Spenard mentioned that their return on equity witness is not going to be here to receive cross-examination in person. That is the same for Kentucky American's return on equity witness, Dr. Vanderwyde. I identified just the two we expect to call by telephone, but there has been an agreement for Dr. Vanderwyde and Randy Woolridge to not appear, with the caveat that those two individuals may receive written questions either during the hearing or, according to the Commission's order that was issued yesterday, after the hearing. And certainly Dr. Vanderwyde will respond to any of those questions under any time frame that the Commission has in its order. So we'll go ahead and call David Baker now on the telephone, if that suits Your Honor.
It does.
Good morning, David Baker's office.
Yes.
Is David in, please?
Yes, who's calling?
This is Lindsey Ingram at the Kentucky Public Service Commission.
Lindsay, hold on, please.
Chairman, do you want to go ahead and swear him in first?
I will.
Okay.
Good morning.
Mr. Baker,
Yes, good morning. This is David Baker.
can you hear me?
Yes, I can, but give me just a moment. I need to turn the sound off on my computer. I'm watching you by video.
You may get a little feedback.
Okay, now that's better. Yes, this is David Baker.
I'm going.
And with me, with me I have Ed Hay, our corporate counsel.
Very well. Welcome, Mr. Hay. I'm going to swear you in.
I'm sorry, I didn't understand your
I'm
question.
going to swear you in to tell the truth, nothing but the truth, subject to the rules of perjury.
I do.
Thank you. Your witness.
Mr. Baker, this is Lindsey Ingram. Thank you for appearing by telephone today. You did not file any pre-filed written testimony, either direct or on rebuttal. Is that true, Mr. Baker?
Yes, that's true.
But is it your understanding that you have been requested to be available today for cross-examination by the Commission staff on some issues that have arisen in the Kentucky American case? Is that accurate?
Yes, it is.
Okay. And could you please state your job and your business address?
Sure. My name is David K. Baker. I'm the Senior Vice President of American Water's Northeast Division and also the President of New Jersey American Water. And my address is 1025 Laurel Oak Road in Voorhees, New Jersey.
Okay, Mr. Baker, I'm going to make you available for cross-examination. I expect that will happen by Mr. Jerry Woocher, lead counsel for Commission staff. Mr. Woocher?
Good morning, Mr. Baker. Can you hear me?
Yes, I can. Good morning.
Okay. Thank you for appearing this morning. Let me begin by asking, you said that you're Senior Vice President for American Water Works Company Northeast Division. Is that correct?
Yes, sir.
Okay. How long have you been an employee of American Water Works Company or one of its affiliates?
Between 18 and 19 years.
And have you ever been assigned or employed by the Kentucky American Water Company?
Yes, I started at Kentucky American Water. That's the place I started in 1995.
And how long were you employed by Kentucky American?
Until January of 2001.
Okay, and what positions were you employed while at Kentucky American?
I was the Director of Customer Service for a time, and I was the Director of Business Development for a time.
And would you say you're familiar with Kentucky American's operations?
Relatively, yes, although I haven't been there for many years.
Would you say you're familiar with Kentucky American's provision or previous provision of billing services to the Lexington Fayette urban county government?
I did work with that contract back when I was at Kentucky American, so I've not actually worked with it since 2001, but I was very familiar with it when I was there, yes.
As an employee of American Water Works Company, were you at some point in time assigned or a member of American Water Works Business Transformation Steering Committee?
Yes, I had a temporary assignment as part of the BT Steering Committee during the months of June and July of 2011. I was asked to do that as our corporate president, Walter Lynch, was away at school, and he asked me to sit in for him in that capacity, yes.
And aside from that temporary assignment, did you perform other tasks for the Business Transformation Steering Committee outside of that time period?
Walter Lynch asked me right at the end of May of 2011 to oversee the transition of billing services as related to BT, yes.
Okay, and let me step back for a second, because I'm using the term business transformation and you're using the term BT. I assume they're both the same, but could you briefly describe what is meant by to you and to American Water Works in terms of the phrase business transformation?
Business transformation relates to a couple of things. Number one, it's the integration of all of our, and this started several years ago, it's the preparation for the integration of all of our disconnected systems, if you will, into an SAP platform.
Yeah, I hate to be dense, but I'm going to be dense anyway. SAP stands for?
I don't know. I don't know what it stands for. It's a large IT platform that's been around that a lot of companies use, but I don't know what it stands for.
Okay. In terms of the business transformation, what was the purpose of the steering committee?
As a temporary member of the steering committee that came to be a temporary member several years, I think a couple of years after it was formed, I'm going to take an educated estimate as to what the steering committee's purpose is, but it is to, my belief is that it was to oversee the varying aspects of the conversion to SAP over the course of time.
Would it be correct to say that that committee made the final decisions regarding business transformation practices?
Yes, but you can't say that it's all inclusive. We have many, many practices in our business that don't relate directly to business transformation or to SAP.
Okay, and I guess I'm just trying to generally right now to figure out where that steering committee is placed. If the steering committee made a decision, would that decision then be one that would be sent down to the rest of the American Water Works Company and its subsidiaries, saying this is the course of action that we will take?
Generally, yes, but to be clear, each of our subsidiaries has a president who has a fiduciary duty along with their staff to make decisions on that regulated utility and to apply decisions or make choices about applying decisions based on their duty and their obligation on a local basis. So I don't think it's really correct to say that there's a blanket decision that would have to be uniformly applied in most cases.
Okay. Let's go to billing practices. I believe the term, as it appears in some of the minutes of the business transformation steering committee meetings, it makes reference to managed contracts. Is that the same thing as third-party billing services?
Yes, I believe that refers to the same thing.
And I guess managed contracts would include contracts for providing billing services for other utilities, such as Kentucky American's previous provision of billing services for Lexington Fayette Urban County government's sewer facilities. Is that correct?
Yes.
Okay. At the time, you began your review, I guess, of the issue of managed contracts sometime in June of 2011 when you became a temporary member of the steering committee?
Yes.
Okay. Do you know if any work on that, or to your knowledge, had any work been done on that issue prior to your temporary assignment to the committee?
Yes, there had been some work done prior to that.
What type of work was that?
In early 2011, and I would say this was outside the realm of the steering committee, but our executive leadership team had made the decision that where possible we would try to transition out of billing services contracts. So the division heads, such as myself, we had 4 divisions at that time, were asked to begin looking at that. So in my previous role as the head of the Western Division of American Water, those states that reported up to me, they were asked to begin taking a look at this and making assessments and so forth. So that did occur before my stint on the steering committee.
Okay, so am I understanding you to say that the actual decision to depart the third-party billing services market had been made by the executive leadership in early 2011, even before the issue had been raised to the Business Transformation Steering Committee?
I think it's very difficult to separate the two. What I was saying is it was made prior to my involvement in the steering committee. So I really can't speak to how much of it came from the steering committee, but the instructions that were given to me and my counterparts at the time did come from our executive leadership team. If you don't mind, Mr. Utra, I'd like to add a point of clarification.
Please go ahead.
Okay, thank you. When you state that the executive leadership team made that decision, I think it's really important to understand that the way that we're organized at American Water, in this case with reference to the BT Steering Committee, that's a very much a high-level policy level review committee that sets direction and so forth. But as with everything that we do at American Water, we're organized on a state regulated subsidiary basis, and that's why we have presidents, and they are presidents. They make their decisions based on what they need to do at the time in the best interest of their business and their customers. And so that's why myself in my Western Division role before consulted with my presidents, nothing to do with Kentucky. Kentucky was not one of my states, to begin assessing this situation. So what I was trying to prove, the point there is that the ELT did not make a decision that we will get out of every single contract. That was not the decision made at that time.
Okay. As I understand them, you're saying there is some individual discretion on the part of the subsidiary companies. Is that correct?
Yeah, discretion and duty, as importantly, yes.
Okay, and getting back again, but the division heads had been alerted early in 2011 to begin to assess and at least look at the possibility of leaving the third-party billing services market.
That's correct.
Okay. And when you came on to the, and just so I can make sure I understand the executive leadership team, who are we talking about there?
That's our CEO, our CFO, and my boss, our president of the regulated utilities, and our head attorney, and so on and so forth.
Okay, these are, and I don't mean to put words in your mouth, and I'm trying not to create the wrong impression for you, but are you saying these are all the people that are basically at corporate headquarters in New Jersey? That's where the senior leadership team would be?
Yes, that's correct.
Okay. When you came on to the Business Transformation Steering Committee in June, were you assigned to look at the managed contracts issue?
Yes.
Okay, and were you given any instructions or indication as to how the managed, what the company what the overall company-wide policy should be?
Yes, it was recognized, and the communications that I believe that you have in discovery indicate that that general decision had been made that we would exit those contracts, but in each of those communications it also states that we realize that there could be contracts that will not be exited, and so some provisions were made for how we would deal with, or more importantly, how each individual state president would decide to deal with his or her individual contracts with regard to conversion costs and with regard to services that SAP may or may not be able to provide, and standardization of contracts and so forth.
Okay, well, let me follow that up because I'm trying to make sure I understand. The decision was made to exit, but there was a recognition that there might be some cases where either the third party or the subsidiary company would want to continue the billing relationship. Is that correct?
I'm going to, let me clarify that a little bit further, because the way you stated it, I don't think it's exactly what I said.
All right, please do so.
Sure. What I said was that each subsidiary would have to weigh through that. I didn't say that each client or municipality would be able to weigh through that. They have an individual agreement, and both parties, which would be the state-regulated subsidiary, because American Water, the parent, is not a party to these contracts, but that state regulated subsidiary head and that local municipality or client would work that out on their own.
Okay, as I understand it, at the time you were reviewing this issue in mid-2011, there were about 156 billing contracts for all the American Water Works subsidiaries. Would that be correct?
Yes.
Okay, and would it be correct to say that, I guess, the largest contracts in terms of customers was the contract that Kentucky American had with Lexington Fayette Urban County Government?
I can't recall the statistics, but generally I believe that I recall Lexington was the largest, yes.
Or would it be correct to say that many of the billing contracts involved smaller utilities or the issuance of bills to customers that were less than 1,000 customers?
I couldn't speak to that. I know we had many that were larger than 1,000, but I don't have a breakdown in front of me of the size.
Okay, if I told you, subject to check, that at least in June of 2011, the number of customers that Kentucky American was billing for sewer service was about 104,000 customers, would that seem about right to you?
Yes, it would.
How about in terms of for storm water service, about 95,000 customers? Would that be in to your recollection?
No, my recollection is that roughly the services we were billing for Lexington, it was for around 100,000 customers. I don't know. I never knew what the breakdown was between various.
Okay, and the next largest entity that a subsidiary was billing for would have been the American Water Works subsidiary that was providing service to Chattanooga, Tennessee. Is that correct?
And I don't have a list in front of me of the various contracts, no. I can't verify that, no, I can't.
Would you agree on that the contract Kentucky American had with Lexington Fayette Urban County Government in terms of the bills, that it was probably one of the more unique ones in terms of the number of customers?
I would say it was, I don't know if I would say it was unique. I would say it was the largest, or at least close to being the largest to my knowledge.
Okay. Now, according to the minutes of the Business Transformation Steering Committee, you were scheduled to make a presentation to the steering committee. You were present at the steering committee on June 30th of 2011. Do you recall that meeting?
No. Can you provide for me or give me a reference of what you're looking at, please?
I was afraid you were going to ask that. There is what I'm looking at is the minutes of the June 30th Business Transformation Steering Committee meeting. The actual document is confidential, but there is, without revealing the contents, there is a notation that references you scheduled to make a presentation to the committee at the July 13th meeting.
Yeah, to be clear, I believe I now have that document in front of me, but let me, Mr. Wucher, let me just make sure. It says Business Transformation Steering Committee. And is there a reference on the top that refers to?
I can tell you the reference as it has been numbered for confidentiality purposes. It's at the very top. It would read, well, first of all, the heading of the actual document reads Business Transformation Steering, June 30th, 2011 meeting, action items and minutes, Voorhees, New Jersey. And then there's an imprinted reference, KAW _R PSC DR3 number 24 CONF _032013, page 101 of 188.
So yes, I'm embarrassed to say, Mr. Wucher, that my answer is yes after you went through that giant explanation. I have that in front of me, yes.
That's quite all right. Now, do you recall if you made any presentation at the June 30th meeting?
I don't recall if I did or not.
Okay. Do you recall making a presentation on the July 13th meeting?
Again, I can't recall that specifically, but do you have any document of reference that I could look at?
Again, I think the reference I'm looking at is the minutes of the July 13th Business Transformation Steering Committee meeting.
Okay. If you'll give me a moment, let me see if I have that. And for expediency, Mr. Wucher, would you give me at the top the CONF and then those the page what of what, just to make sure.
Okay. Let me give you the page number. It would be page 104 of 188, and it would be referenced again to PSC DR3 _number 24.
Yeah, my page numbering may be different here. What I'm looking at is the July 13th. 2011 BT Steering Committee meeting action items and minutes. Is that the same?
Yes,
document?
I believe that's the same. And without going ahead and disclosing too much of the contents, at the very bottom in the right-hand corner, there's a number 2. Do you see that on your copy?
Yes, I do.
Okay, and there's a reference about a quarter of the way down to an Andrew and Chris.
Yes.
Okay. In the middle of the page, there is a reference to you, David Baker. So do you have that?
Yes, I see that.
Okay. I have a couple of questions about that reference. So let me first, do you recall making the presentation on July 13th?
Truthfully, I don't recall it, but if it's in the minutes, I'm sure I did.
Okay. Well, when you made the presentation, to the extent that you can recall, what exactly was the gist of the presentation?
Mr. Wucher, I cannot recall the presentation, so I'd hesitate to say what I recall from it because I don't recall anything. I'm happy to speak to the process at that time. I think I can recall generally, but I can't tell you what I said at that meeting.
Oh, okay. Well, let's step back a second before you do that. To the extent you recall, was there any type of PowerPoint presentation or written presentation provided to the steering committee when you made your presentation?
Not to my knowledge. I certainly don't. I don't believe I have it in front of me either.
Okay. Well, Well, let's go back then. If you'll look at the reference that is made in the minutes, can you tell us, at that meeting, was a decision made to exit all managed contracts?
No, and I can tell you by reference to other materials that I do have, that there was not a decision made to exit all contracts. In other words, to eliminate the discretionary piece that each state would have. That decision was not made until the end of 2011, December of 2011.
Okay, so let's talk about that then. There was a decision made to at least discourage continued use of managed contracts?
That's true, and to provide a means by which, if the contracts were to continue, that they would be enabled in SAP and the costs and so forth.
Okay, can you clarify that? If, let's take a hypothetical and work it from there. If you had a City A that had been receiving billing services from an American Water Works subsidiary, and the what was the American Water Works subsidiary required to, by the guidance provided by the Business Transformation Steering Committee, to terminate that contract?
Sorry, Mr. Wucher, I don't think I really followed all that as a question. Can
All
you
right.
repeat that?
Well, let me rephrase it. It was kind of poorly worded anyway. Was the guidance, as you recall, from that meeting that the subsidiaries had to terminate all managed contracts?
No, that was not the guidance. If you're referring to the July 13th meeting, no.
Okay, and
What I
if
stated is that decision was not made until December of 2011.
okay, was the guidance to suggest that managed contracts were strongly discouraged?
I believe that's correct.
Okay, and what was the guidance in terms of to the subsidiaries in terms of subsidiaries that wanted to continue doing the managed contracts?
They would have worked, not with me, but they would have worked with members of the BT team that had more direct knowledge of SAP and what would have to be done to continue that contract in the new format. But to be clear, those services were not going to be the same services that the municipalities were getting pre-BT or SAP conversion, because there was a single platform that was going to be established for billing contract services that every client or every municipality would be using, regardless of the services they were getting today. So I just want to make sure you understand that even though they had the latitude, there was that those services would change.
Okay, so
possibly change.
So there would be a uniform template, essentially, for any billing services that still would be provided?
Yes, that was part of the instructions throughout 2011.
Okay, and I guess I'm trying to understand, because in looking at some of the material, it seemed to suggest the idea that the guidance was terminate these contracts at the earliest possible date, and if the contracts are to continue, then continue with the contracts and carry them on until you're legally no longer required to do so. Is that an improper interpretation of the guidance?
I don't believe that the latter portion, the legally required to do so, was anywhere in the guidance, at least as I looked through the memos that I sent out.
Okay, so your understanding was it wasn't those that were to continue to do these billing contracts, there wasn't something where the subsidiaries were just kind of carrying on these processes until the expiration of the contract or until the third-party client found some other means to have their billing services performed?
Again, I think you characterized it, or I characterized it correctly before. We encouraged, or we strongly encourage, our subsidiaries to exit the contracts. But again, that there was latitude for each of those states to make their decisions.
Okay, and what I'm trying to get at is I'm trying to find if there was an exit date where, or some point in mind where all these contracts would be exited, or a subsidiary would still have the discretion to carry on these third-party contracts out 5, 10, 15 years, so long as that subsidiary deemed it to be in the best interest of the subsidiary and had arrangements that did not impact the rest of the American Water Works system.
No, I think as I stated earlier, the decision to exit all the contracts, period, was made in December of 11. So I'm not sure I'm able to give it any more color or description than that.
Okay, let me go ahead and do you have a copy of your email to of August 1, 2011 to, it looks like, various presidents of the subsidiary companies?
Yes, that I do have it.
Okay, and just so that we're working on the same sheet of music, do you have a copy of that? And just so everyone here in the hearing room is following along, I'm going to go ahead and ask Mr. Byer to hand out a copy of the email message. And to confirm for all of us, the email message at the top has is listed as page 2 of 33.
That's correct.
And it has on it KAWNDR_PSC-3_NUM29_CONF032013. So that we're looking at the same document.
Yes.
Okay, now there are additional pages to that, but I'm just going to focus right now on page 2. At the beginning of the message, there's a statement that reads, "President and other leaders, per our recent meetings and emails, the decision has been made to exit all billing contracts within the regulated business." Do you see that, sir?
Oh, yes, I do.
Okay, now, that statement seems to suggest that all contracts have to be terminated.
If you'll read on to the fourth paragraph, it states the ELT has decided that the cost of retention of any of these contracts will be borne by the states which retain them. So yes, we were strongly encouraging folks to get out of this business, but we understood that each subsidiary may decide, have to make that decision to retain them.
Okay, and can you, ELT stands for what?
Executive Leadership Team.
Okay. Okay, I guess I'm a little confused because at the very top you're saying that everyone needs to get out and your team should be beginning to prepare the clients now for the exit. The next sentence reads, you need to determine which contracts cannot be terminated by October 31, 2012. So are you looking at terminating all contracts with just a rump that cannot be terminated by then, but intending on terminating them at some point? Or was the intent that there could be a few outliers that survive?
I believe it was the latter because, American Water, the parent, is not a party to these contracts. And so it was clearly understood that there was a possibility that some of these contracts may continue. And that's why the provisions were being made, as I read earlier, to retain.
Okay, and I just want to make certain. You're saying, and I apologize to keep on repeating this, but I'm a little confused. When you say that it was still up to the discretion of the state subsidiaries, then those states could go ahead and continue the billing practice. But they would,
I'm sorry, I didn't let you finish. Go ahead.
no, go ahead.
No, please bear in mind that, and as you see the progression of the emails that I know you obtained in Discovery, this was an iterative process that took place throughout 2011. And so we progressed from a strong encouragement in the beginning of the year and with the statement and the clear mechanism made available to the states that if you have to continue them, here's what it would, here's what it may cost and that sort of thing. But that iterative process ended up in December of 11, more than, 4 months after this. That's when we made the decision that we would exit all of them. That's when it became firm.
Okay, and I apologize. I'm trying to make sure. So in the August 1 message, you're basically saying we would prefer to have all these contracts eliminated, but some can remain. The company's position evolved, whereas by the end of the year, it did not want any billing services.
That's correct.
At the time that the August 1 letter went out, did you have very many of the state subsidiaries indicating that they wanted to keep third-party contracts? Or would you know?
I'm afraid I really can't recall what the status was at that time.
Well, were you president of New Jersey American at that time?
No, I was not.
What were you an officer in one of the state subsidiaries at that time?
No, I was a senior vice president of the Western Division, which was I was over all the presidents of the Western states at that time.
Okay, in terms of the area that you were over in the Western Division, did any of them have contracts that they continued or indicated an interest in continuing?
I can't recall what the status was in August of 2011. There were various contracts, though, in the Western Division, I believe, in Missouri and Illinois. But I don't recall the status at that time, no, Mr. Witcher.
Okay, and were you involved in any of the discussions after you left the Transformation Committee, it appears, after July? Were you involved in any of those discussions after that point in time, or any of the decisions made as the company's position evolved?
I wasn't involved in the decisions. My role was to continue as a project leader, I guess is the best way to put it, for my boss, Walter Lynch, our regulated president, to gather information, and John Clarkson, my Western Division Director of Customer Service, coordinated with his counterparts to keep tabs on that. But no, I was not involved in the decisions. Those decisions were made by each state president in dealing with their contracts.
Okay, to the extent possible, can you tell me, to your knowledge, what was the cause of the evolution from going from a discouraged but permitted billing practice to complete termination of billing services?
I believe over the course of that year, particularly in the latter half of the year, as each of the states worked with their municipal clients that had these billing contracts, I think toward the end of the year it became clear that there were very few remaining that were interested in, under the new circumstance, continuing on with that service with us, or the state was interested in continuing on with the service as the other party to the contract. And that being the case, that's why we made the decision, or I did not make that decision, but that's why the decision was relayed to me that stated we're going to get out of the business because there essentially aren't hardly any contracts left that want to stay.
And was one of the factors just the fact there were such a limited number of companies left that or limited number of third parties that wanted the service?
I'm sorry, could you? I don't think I followed that.
Well, let me put it this way: if you did anyone raise, was there a limited number, a floor that of companies or customers that had to be available in order to even permit the service on a discretionary basis?
I'm sorry, Mr. Wutcher, I don't mean to be dense. I'm not sure.
No, that's
really
okay.
understand
I'm
your
probably not. What I'm asking essentially is, you had 156 contracts originally. The number was declining. Was there a point where the company had done an analysis that said it would just be too expensive if we only had one or two individuals wanting our service or wanting third-party billing services?
I don't believe that there was a change in the expense. All along, we knew there would be a very substantial fixed cost to set it up in SAP. And so I don't believe so much it was the expense. I believe it was the fact that this was not a core business service for American Water. These billing contracts made up less than 0.3% of our regulated utility revenues, and therefore, since there were just maybe a handful at the end, and again, I didn't make that decision, but my understanding was since there were just a handful or one or whatever the number was, in December it was decided we would just exit all of it.
Okay, let me go ahead and turn your attention now to get some clarification to an email that you sent to Cheryl Norton. The email is dated February 9, 2012. And we're going to go ahead and pass that out.
I have that.
You have that?
Yeah.
And can you take a look at that very quickly? I have a couple of questions about it.
Yeah. Yes, I have it. I'm ready.
Okay. Now, in the exchange, you make the statement that in the end, the steering committee decided to exit all of the contracts regardless of the willingness of the subsidiary or client to assume the cost of SAP implementation. You see that?
Yes, I do.
Okay, and then you go on to state, we will be completely out of that business line, period. Then you state that decision was made several months before you contacted the city.
No, sir. It says that decision was made several months after you contacted
I'm sorry.
the city.
So, but I've just got a few more questions. Do you know, was part of the reason for eliminating third-party billing the limited availability on the bill itself? In other words, billing for various services limited the what the company could bill for its own internal practices or services?
I'm going to state back your question and give you an answer. Let me make sure I got the question right. I don't recall or know that there was some sort of limitation on what could go on the bill. I don't recall that.
Okay. Do you recall if there was any discussion at the business transformation meetings about initiating billing for other services?
I don't recall that there was, no.
Okay, well, I'm going to refer back to I think it was the attachment to your email message of August 1st of 2011. And this was the American Water Billing Services Communication Plan. Do you have that in front of you, sir?
I do.
Okay, and there's a sample letter related to termination of service that was, I think, provided to all the state subsidiaries. And,
Would you mind giving me an exhibit number or whatever this is?
yes, sir.
Page 7. Is it page 6? I think it's page 7, isn't it, Jerry?
There's one here, too.
Yeah.
No, I'm...
6 or 7.
It is actually it's page 6 of 33. I'm sorry.
Yes, I have that now.
Okay, and it's labeled number 6, sample contract termination letter.
Yeah.
Okay, in the second paragraph, there's a reference to the ability to support billing services, and it says at the bottom of the second paragraph, last sentence, with the needed changes in company technology, our ability to support billing services for outside organizations is limited.
Yes, I see that.
Okay, and was that related to just the technology of having additional services billed aside from the core American Water services?
Yes, beyond billing for our water charges or our sewer charges if we were the sewer utility provider.
Okay, and let me follow that up by just asking, at a prior meeting, well, first, does American Water Works American Water Works Company have an affiliate named American Water Resources?
Yes.
Is that also known, I guess, as homeowner services? Does it go by that name?
We have a subsidiary that's generally known as Homeowner Services. I don't know that that's all of American Water Resources.
Okay. Do you know what type of services that American Water, what that Homeowner Services provides?
Yes, it's a service line protection program that certain consumers can purchase if they so choose. It's a part of our non-regulated business.
And was it agreed by the Business Transformation Committee that that service should be incorporated into the new billing system so that the subsidiaries could bill for it?
I don't know. I was not involved in that, and I don't recall the discussions if there were any while I was on the committee.
Okay. I think that's just about it. Give me just one moment.
Okay.
Let me refer you back again to your August 1st, 2011 email message. And this question is raised to you, but it's actually directed to counsel for American Water Works. You reference your recent meetings and emails. Do you know, could you identify for us or provide copies of the email messages that you are referencing in your email message of August 1, 2011?
If the question is to counsel, yes, Chair, we've identified at least a few emails that have already been produced in discovery from David Baker to some others. on this topic, I can give you sites to the record where those are located.
So those are already in the record.
Well, to the extent that we have reviewed the record and found those David Baker emails, yes, those are what we have found. I would assume those are the same emails to which Mr. Baker refers in his August email. He'll have to answer that, but the connecting the dots is pretty easy, I think.
Well,
For me.
yes, sir. Let me, if I may, let me just make a request then. If Mr. Baker, if the company could review with council those items they've already identified in the record, and if those are the complete emails that Mr. Baker is referring to, if you could just advise us of that. If there are additional emails to which Mr. Baker would be referring, if you could provide us with a copy of those.
Absolutely, Mr. Witcher, and so we're clear today, and Mr. Baker is clear. I think the ones we're talking about that preceded the August email are the June 24th, 2011 email from Mr. Baker and a June 30th, 2011 email from Mr. Baker, both of which were included in the response to commission staff data request set number 2, item number 77. And Mr. Baker, we can talk later, if it's okay, and figure out whether there are any in addition to those two that we'll provide to the commission.
Certainly, and those are the ones that I have right here today, June 24th and June 30th. I don't believe I have any others.
The other request we would make, if Kentucky American would review the emails that are already in the record from the August 1 date to the December decision date, and identify if there are any other emails that were sent out by either Mr. Baker or other members of the steering committee that provided guidance and reflect the evolution of the company's change in position.
Absolutely.
And I believe that's all we have. Thank you.
Richard, do you wish to enter these documents you passed out earlier?
No, Your Honor, I don't. Those were handed out solely for solely to allow the council and for the commission to follow along as we question the witness. And so I would not ask that they be made. They're already a part of a record, and so given that, I really see no need that they be entered into the record.
Very well.
I have one question on that, just so we can set the stage for what's going to happen further. If we want to bring these exhibits up again for another witness, does it make any sense for those to be identified, not as a hearing exhibit or something, those to the record, just as staff and staff too, for ease of...
Recognizing that, in order to make matters more easily administered, we would ask that those exhibits be numbered, and we can get with the court reporter at the break, but I believe there's 3 of them labeled as commission staff exhibits 1, 2, and 3, but they would be offered only for identification purposes only and for no other purpose.
I think there were just 2.
There's just 2.
I think there were just, all I got was 2.
I'm ahead of myself. I apologize.
Okay.
And I believe the first one we referred to was
Is that confidential?
the
Multi-page one.
was the one that begins page 2 of 33, the August 1st, 2011 email message. If that could be labeled as Commission Staff Exhibit Number 1.
Yes.
Okay, that's the packet.
Right.
That includes the email message plus the materials that were part of the response, the American Water Billing Services Communications Plan.
Yes.
And then Commission Staff Exhibit Number 2 would be the email message exchanged between Ms. Norton and Mr. Baker that occurred on February 9th, 2012. It's 1 page.
Thanks, sir.
And I believe that's all we have, Your Honor. Thank you, Mr.
Thank
Baker.
you, Mr. Witcher.
I had a follow-up, a clarification, if you don't mind.
Sure. Mr. Barbary?
Mr. Baker, my name is David Barbary, and I'm the counsel for the Urban County Government. Are you still there?
Yes, good morning.
I had this is just a clarification, if it's not clear enough already. Of the 156 contracts that were mentioned, are there any at all that are currently still being provided billing services?
To my knowledge, I believe there's one in Illinois for the city of Bolingbrook.
Would you mind, if this is okay with Mr. Ingram, just could you supplement, I guess we would do a follow-up data request to have them provide the number as well as which contracts those are?
Yes, that's fine.
I have no other questions.
Ms. Skidmore, did you have questions?
Do you have any questions?
Questions?
Yes, thank you. Mr. Baker, my name is Jim Gardner, and I'm one of the commissioners. Can you hear me okay?
Yes, I can. Good morning.
Good morning. I have just a couple questions. In looking through the emails that we earlier this morning, I saw references to changes occurring, that this was not a core business of American Water. I didn't see any language in those emails about concerns with the increased amount of the billing, and that these billing with these extra services were sending inaccurate price signals to the customers. Are those referenced in these emails?
The emails that I have before me don't reference that, no.
Do you recall communicating that to Ms. Norton in writing or verbally?
I don't recall that, communicating that to Cheryl, no.
Okay. Do you recall conversations when you all were deciding this issue as to whether that was an important point or not?
Generally, let me back up just a moment, Commissioner Gardner. I know part of the underlying decision, and this goes back to very early 2011. I'm going to put a different hat on now. I can't speak for Ms. Norton, but I know prior, when I was a president, there was confusion that was created when charges went out and customers had questions, or they would associate a rate increase by a sewer authority that we were providing billing services for. That could create confusion, and have that rate increase associated with us, with American Water or any particular subsidiary. So that confusion was out there, but I don't believe I ever discussed that specifically with Cheryl.
Okay, that's a slightly different issue than what I asked. What you discussed and expressed a concern about was confusion among with customers. My concern was more about the amount of the bill and the inaccurate price signals that the size of the bill was sending to customers.
Victor, would you mind asking me your question again? I'm not following you.
Yes, sir. Was a concern raised in your deliberations about the fact that customers or consumers were getting inaccurate price signals as to the amount they were being billed, and you wanted to correct those price signals to customers so that they understood the full value of the water that they were receiving?
Yes, and let me paraphrase what you just said, just to make sure that I'm following. If you mean by inaccurate price signals, did we have concerns that our customers associated the charges on the bill that were not water charges with American Water or that subsidiary's water charges? Then the answer is yes. In other words, that there were, I'll just give an example to make sure we're clear here, that I'm clear with what you're asking. If it's $50 for water and $50 for sewer billing, let's say, on behalf of the municipality, did that customer associate a $100 total bill with American Water or with, in this case, Kentucky American Water? I would say that's a concern that we had, yes.
And that was expressed in meetings that you participated in?
No, it was not. Those sorts of discussions, I'm assuming, happened at the ELT level when they made the decision that we were going to try to get out of this business. I would say that would have happened prior to the meetings I was involved with business transformation and so forth.
Okay. Thank you. I have just a couple questions related to your tenure at New Jersey. Are you currently president of New Jersey American Water?
Yes.
And how long have you been president of it?
Since November 1st, 2011.
Okay. And it's my understanding that in New Jersey that you all use a forecasted test year. Is that correct?
No, it's really a combination. It's partially forecasted is probably the better way to put it.
Let me ask you this: in your since you were there, there's been an order increasing rates in New Jersey. Is that correct? My notes indicate May the 1st, 2012. Is that correct?
Yes.
In that hearing, and does New Jersey make adjustments to the number of customers to determine the billing units based on weather normalization?
I'm sorry, there's some background noise. Would you mind repeating the question?
Yes, sir. In New Jersey, does New Jersey American Water make adjustments to the number of customers so that it can determine what the base usage is per customer?
I don't really understand the question, and if I did understand, as far as making an adjustment on the number of customers for usage, I certainly don't know. That doesn't sound right to me, though.
Okay. And maybe I didn't articulate it clearly, so are you, let me ask one other question. Are you familiar with the concept of FIN 48?
I have no idea what you're talking about.
Okay. That's all my questions. Thank you, sir.
You're welcome. Thank you.
Thank you, Mr. Baker. For the witness?
No further questions, and may he be excused and hang up the phone if there aren't any further questions?
Staff has no further questions of the witness.
No, he is excused.
Thank you, Mr. Baker.
Yes, thank you.
Next witness?
The next Kentucky American witness is Cheryl Norton.
Ms. Warren, solemnly swear to tell the truth, the whole truth, nothing but the truth, subject to perjury.
I do.
Have a seat, speak up loud and clear, your name and what you do and why are you here?
I'm Cheryl Norton. I'm the president at Kentucky American Water, 2300 Richmond Road, Lexington, Kentucky. And I'm here because we filed a rate case.
Welcome.
Thank you.
Ms. Norton, did you prepare and cause to be filed in this matter a written direct testimony along with Kentucky American's December 28, 2012 application?
Yes, I did.
Did you also prepare and cause to be filed rebuttal testimony that was filed last month in this case?
Yes, I did.
If I ask you right now the same questions that were asked of you in that written testimony, both direct and on rebuttal, would you provide the same answers?
Yes, I would.
This is available for cross-examination.
Your Honor.
General?
Good morning, Ms. Norton.
Good morning.
Also, I need to alert to the Commission, as directed in the order, that the Attorney General does wish to advise that we reserve the right to ask Ms. Norton questions regarding the confidential record if necessary. We'll do our best to avoid that as possible, but if necessary, we do reserve that right. And Ms. Norton, I've never been accused of not being able to be heard, but if there's anything that you can't hear, please let me know, and if I need to rephrase a question, restate it, please let me know as well. This is the second time you've testified before the commission, is that correct?
That's correct.
And the first time did occur with Kentucky American's application for the northern connection to Owenton, and just for the record, that was 2012-00096, is that
Yes.
correct? In your testimony on October 16th before the commission, in that case, you confirmed that since beginning your tenure as president of Kentucky American in 2011, you've been serving as the boss. Is that correct?
That's correct.
And I believe, and I quote here, that you stated that you were the ultimate authority for decisions with respect to Kentucky American's operations. Is
That's
that correct? As the ultimate authority over the operations of Kentucky American Water, you've provided the authorizing signature to this application for the rate increase currently pending before the commission today. Is that correct?
Yes.
And you've also attested to the forecast or forward-looking test year utilized by Kentucky American in this rate case?
Yes.
Okay. Under your supervision, how has Kentucky American been performing?
I would say that Kentucky American has been performing very well. We look continuously to make improvements to our operations and be as efficient as possible. We've not earned this past year, in the past 12 months, our allowed ROE, but we're close, and I would say that we've performed well. Our
Okay.
customer service numbers are high. And from an operational perspective, I think we're doing a great job.
Thank you. I'm just taking a few notes here. Excuse me. Ms. Norton, you mentioned the approved ROE. Have you read the Commission's December 14th order in the last rate case, which for the record is 2010-00036?
I have, but it's been a while since I've read that.
Understood. And if you need a refresher, I'm happy to provide copies. But based on your knowledge, what was the return on equity authorized for Kentucky American Water in that case?
I believe it was 9.7%.
And you mentioned earlier, with regard to performance, if you know, what was the actual earned ROE for Kentucky American Water in 2010?
I'm sorry, I don't know the
Don't
answer
know.
to
Okay.
that.
Who would be able to provide that information?
My finance manager would have all the historical ROE information and the details.
Okay. And that is, you'll have to, excuse me.
Sorry, Gina Money.
Gina Money? Okay. And what about for 2011? What was the actual earned ROE for Kentucky American?
I can't be sure that I could give you the exact number, so we can get that information for you if you'd like.
Okay. And what about for 2012? The same?
Yeah.
Cannot be sure. But
I
you
would
can-
not want to put a number out there.
Okay. At this time, Your Honor, we do have some questions regarding the confidential record, but I believe that the agreement was to hold those until we've dealt with non-confidential matters, so I'll do so
That's
at this
correct.
time. Ms. Norton, would you agree that Kentucky American Water is encouraged to be a leader with respect to the regional supply of water in Kentucky?
Yes, I would agree with that.
Okay. And does this encouragement come from your parent company, American Water?
American Water feels that we should try to be a regional partner and work with different organizations and groups to make sure that all the communities in our region have adequate drinking water supplies, and they do encourage us to do that, yes.
Very good. Does this encouragement also come from any local, regional, and state policymakers in Kentucky?
I believe that we've heard from numerous organizations and even the commission that they would like to see some regionalization, and a lot of the smaller systems tend to struggle with being able to meet regulations and operate at an efficient level.
Is Kentucky American currently exploring acquisitions of smaller systems?
Kentucky American's always looking to grow the business and talking to different communities.
And if you're at liberty to share, where generally is that exploration of expansion occurring at this time?
Right now, it's we're looking both in conjunction with our system so that it would be very close to where we're at, but also we would be willing to look in other areas. We've had calls from a couple of different communities that have had some challenges recently, but I'm not really at liberty to share any town names at this point.
Well, and without sharing any specific town names, without going, confidential, what would that generally, you said the general area, that'd be central Kentucky?
Central Kentucky, Western Kentucky, Eastern Kentucky. We would look at any of those general areas.
In northern areas?
Mhm.
Okay.
Yes.
When you last testified before the commission, you indicated that you were made aware of problems at the Owenton facility. Is that correct?
That's correct.
Okay. And at that time, you said, I just wanted for you to confirm here, that you had discussions with Nick Rowe concerning the Owenton facility. Is that correct?
Yes.
Did you also have discussions with other Kentucky American employees?
Yes, once I came here in 2011, I had the opportunity to talk to my team and find out where our strengths and challenges were throughout the business and what things we needed to be focused on going forward, kind of in a strategic type of way.
Did that include discussions with Linda Bridwell?
I'm sure it did, yes.
And to your recollection, what was Linda Bridwell's title at that time?
At that time, Linda was the, I believe, the Director of Environmental Compliance and Water Quality.
Okay. And what was Ms. Bridwell's responsibility with respect to the Owenton facility at that time?
She would have general oversight of any environmental issues that we had or water quality compliance issues.
Did your discussions also include Lance Williams?
Yes.
Okay. And what was Mr. Williams' title at that time?
He was Director of Engineering.
And what were his responsibilities with respect to the Owenton facility?
He would have been responsible for any capital projects, any capital investment to that facility to solve any kinds of issues or to help improve the performance of that facility.
Is Mr. Williams still an employee of Kentucky American?
He is not.
And what was his end date?
Subject to check, I think it was February 13th of 2012.
Of 2013?
I'm sorry, 2013. Thank you.
Understood and noted. And that was after he gave testimony in case number 2012-0096, which I believe occurred in October of 2012.
That's correct.
Okay. So going back to 2011, when you came aboard and discussions of the Owenton facility, did your discussions at that time also include Dillard Griffin?
Dillard was only here a short time, and he retired shortly after I came here within a few months. And I don't recall any specific discussions that I had with Dillard regarding Owenton at that point. He was in a role that didn't have any responsibility for the Owenton facility at that time.
What was his role at that time? Do you recall?
He was in charge of our field services, so I believe he was the manager of field operations.
Field operations.
In the central division, so he didn't have any responsibility in the Owenton area, as I recall.
But he had oversight of Owenton at an earlier time in his career. Is that?
I believe so. He was in charge of production, which would include treatment plants.
Okay. Ms. Norton, based on your understanding of the proceedings in this case today, are you aware that the Commission is incorporating by reference the evidence and pleadings presented in case number 2012-0096 regarding the Northern Connection?
Yes, I am.
Okay. And in that proceeding, in response to PSC staff's first round of data requests, do you recall that Kentucky American provided, and subject to check, approximately 150 pages of emails in response to, and this is more for counsel, note to the record, PSC data request 1-3.
That sounds
Series of emails.
logical. Yes.
Sounds correct. This time, Your Honor, Attorney General would like to pass out an email that was contained in that. I'll pass this down. Ms. Norton, and just for the record, could you note at the top of the page, the tab that this is indicating that it was Kentucky American Water's response, PSC DR1 number 3, 072312, page 47 of 147.
Yes.
And that's the page you have in front of you. Thank you. And just for the record, Your Honor, we would like to go ahead and have this marked as OAG Exhibit Number 1.
Without objection, so ordered.
Just make it easier to refer to. And now that we've had that, could you explain, Ms. Williams, or just at least confirm, does this indicate that this is an email from Dillard Griffin to Lance Williams?
Yes, it does.
And the date of that email is November 18th, 2008?
Yes.
Okay. And could you read this email into the record for us?
Sure. Lance, do you know the status of the investigation about the long-term plans for the Owenton water treatment plant? I know that some were looking into evaluating the site to see the probability of connecting the Owenton distribution network into the new pipeline, or should we leave the plant in service? Also, do we know the status of the chemical repair and upgrade project that was planned? I'm hearing rumors that we may want to leave that plant open and not consider connecting it into the new pipeline network, and that the plans are to proceed with the chemical upgrades. If this is the case, then there is much more work that we need to start planning for, one being a plan for disposing of the residuals which have accumulated at the old plant site. If we are going to continue to operate the existing plant, then we need a residuals plan, then we need to get into a budget a plan for this. If you can provide an update on the status or the current thinking about the existing plant, then we will know more about plans for maintenance equipment and some more firm multi-year operating plans, with residuals disposal and the existing old plant being large items that we need to get an operating plan in place for. It was sent by Dillard Griffin.
Ms. Norton, based in part on this email, but also your own understanding, can you confirm that there was no definitive plan for upgrading the Owenton facility in 2008?
I can't confirm that. Based on the email, I think there were questions about the specifics of that plan.
And those questions were of concern to Mr. Griffin based on the email?
Yes.
And he communicated those concerns to Mr. Williams?
It appears so, yes.
And when you came on at Kentucky American in 2011, did either Mr. Williams or any other employee express the concerns that Mr. Griffin had at that time, or any additional concerns regarding the Owenton facility?
At some point after I came there, not a really long time, because like I said, we sat down and started talking about what the concerns were as a company. And one of the items that we knew that we needed to have conversations about and try to make a decision about was that Owenton treatment plant. And there had already been some work done where I believe they had gotten some engineering studies. I think they were from 2008, but I can't swear to that, to look at what those upgrades needed to be for that plant in order to have the type of redundancy and be able to take portions of the plant out of service to maintain it, what exactly needed to be done at that point. And so we had conversations about that and what our alternatives were. So yes, I think that they had already started creating that plan to decide what was the best alternative there.
But you made the definitive decision regarding what to do with that plan.
I was one of the decision makers, I would say. That I worked closely with Keith Cartier, who's my Vice President of Operations, and Lance Williams, who had the engineering background.
And based on their recommendations to you, though, you made the final decision with respect to Owenton in 2011.
I would say the decision was a consensus, but yeah, push come to shove, I would have made that final decision. I believe it was the right decision.
So would you agree in your role as boss and providing the leadership of Kentucky American that from day one, the Owenton treatment facility was a problem in need of a solution?
Just based on the background that I know, I was not there, so I don't know. But when I first started at Kentucky American, we recognized it as something that needed to be addressed, yes.
Ms. Norton, you've testified that you've read generally the December 14th, 2010 order with regard to the last rate case.
Yes.
Is that correct? Okay. And are you familiar in that order with ordering paragraph number 13 to the final order.
You'd have to tell me what that paragraph
Fine.
says, sorry.
We have that, so. And I'm going to provide a full copy to council of the order,
Yes, thank you.
and then distribute the page that I wish to reference.
I'll just give her the full copy.
Okay, that's fine, and let me just give the page then to you and
Sure, thank you.
council, and to reporter.
Pages.
Thank you.
Very last, or second to last, very last.
If you could locate paragraph number 13, which is ordering paragraph 13 that I referenced before.
Yes.
Okay? And so this is and the page number is 87 of the full order, is that correct?
Yes, that's
Okay.
correct.
At this time, Your Honor, we would like to enter this as OAG Hearing Exhibit number 2.
Without objection, so ordered.
And could you read for us ordering paragraph 13? I believe it's 3 parts, A, B, and C.
Yes. Within 60 days of the date of this order, Kentucky American shall initiate the collaborative effort described in this order by convening a meeting of all interested parties to include all parties of record in this case to identify and study potential regulatory and legislative solutions to enhance and improve the affordability of water service for low-income customers. Part B says, no later than January 31st, 2011, and every month thereafter, Kentucky American shall file with the Commission a written report on the efforts of the collaborative group to develop potential regulatory and legislative solutions to enhance and improve the affordability of water service for low-income customers. C, no later than November 1st, 2011, Kentucky American shall file with the Commission a final written report on the collaborative group's efforts.
So based on the reading of ordering paragraph 13, would you agree that it requires action, would you state whether this ordering paragraph requires action by any party other than Kentucky American?
I believe that it ordered action by any interested parties to join us. That would be any of the interveners, is how I read that.
And subject, obviously, to the commission interpreting its own orders, and I'm not asking you to be an attorney here, but would you agree, though, that the Kentucky American is indicated as shall initiating those collaborative efforts?
Yes.
And the scope of the charge for Kentucky American Water was to consider, and I'm quoting here, regulatory and legislative solutions. Is that correct?
That's correct.
And again, without asking you for a legal opinion, just your own understanding, do you believe that the Commission's order limits Kentucky American Water and the other participants, as you referenced, from considering a variety of options to enhance and improve the affordability of water service for low-income customers?
I don't know if the Commission, I can't be sure what exactly they were looking for, but I think that there was a logical order of the types of solutions that could happen to try to satisfy this desire to find improvement for low-income customers.
But there's no limit in this particular ordering paragraph of those kinds of solutions?
It appears that there's no limit.
Okay. When you began your tenure, did Kentucky American have under contract or otherwise employ a lobbyist or lobbying firm who could assist Kentucky American with legislative contacts?
Yes.
And who was that firm or that party?
The firm that we have is McCarthy Strategic Solutions.
Okay. And is that a contract relationship with
Yes.
that entity?
Yes.
Okay.
We also, at that point, had a government affairs person who worked for Kentucky American. His name was John Mark Hack.
And Mr. Hack was actually an employee of Kentucky
Yes.
American, is that correct?
Yes.
Okay. So in 2011, well, let me back up for a moment. In your rebuttal testimony, you discussed a series of collaborative meetings. To your knowledge, in 2011, did Kentucky American have either Mr. Hack or anyone from McCarthy Solutions present at any of the collaborative meetings convened to discuss the low-income efforts?
Yes.
And which meeting would that have been?
I believe that John Mark Hack was probably at all the meetings that year, or at least the majority of those meetings. I believe I only attended the first meeting that year and then turned it over to others in the business.
After the meetings in 2011, did you or anyone else at the Kentucky American meet with legislators in anticipation of the 2012 General Assembly?
I don't know. I don't know if John Mark had those conversations with them or not. I did not personally meet with them.
And did you ever have a conversation with Mr. Hack regarding those meetings? If they had, whether they had occurred or not?
I can't recall, I'm sorry.
Did you or anyone at Kentucky American seek a sponsor to carry the proposed statute which you circulated in 2011?
In 2011, I'm not sure. At that point, we were still drafting the legislation, was my understanding,
Okay.
and I believe that John Mark didn't feel that it was appropriate to circulate that with the legislature until we got all of the interveners to sign on and say that they agreed with that proposed legislation.
And you had that conversation with him?
I had the conversation with him that the legislation was not finalized, yes.
Okay. And moving on now to 2012, who was the lobbyist or lobbying firm in 2012? Was that, again, McCarthy?
They are outside lobbying firm, yes.
Okay. Was Mr. Hack still with Kentucky American at that time?
Mr. Hack, at the beginning of 2012, I believe until the first part of April of 2012, and then he was no longer with the company.
Okay. Was a bill ever introduced in the 2012 General Assembly to address solutions to enhance and improve the affordability of water service for low-income customers?
No, because we were unable to finalize that legislation draft and get all the parties that were sitting around the table to support it or agree that that legislation was appropriate.
What steps did Kentucky American or your external lobbyists take in advance of the 2013 General Assembly to identify a bill sponsor for draft legislation to address that same issue, the solutions to enhance and improve the affordability of water service for low-income customers?
I had discussions at least twice with that lobbying firm,
Okay.
and we had named a couple of different legislators that we thought might be willing to take that legislation forward for us, but until we knew that all interveners had signed off, my lobbyists told me that they just didn't feel like the legislation would go anywhere without the support of the intervening parties.
So is that correct? Is it correct to say that a bill sponsor was not specifically identified, or that draft was not specifically circulated to legislators in advance of the 2013?
I believe we did submit that draft legislation to a staff member of the speaker, but Greg Stumbo,
Okay.
to one of his staff members, but we didn't put it any. We only did that because he asked about it,
Okay.
and we didn't put it out anyplace else.
Okay.
Because again, we didn't have sign off, and we felt like that it was premature to do that. But we had identified at least, I believe, 2 legislators that we thought might take it if we could get that support.
Did Kentucky American seek a bill sponsor or circulate a draft of any other legislation for consideration by the 2013 General Assembly?
Yes, we did.
Other than Order 13, was Kentucky American under an affirmative duty as ordered by this commission to seek a legislative solution to any other matter other than the issue of affordability and low income?
Well, now, I'll object to that question. It involves an interpretation, possibly a legal one, of ordering paragraph 13. Ordering paragraph 13 speaks for itself.
I'm going to let the question stand, if you know.
My understanding by the paragraph is really that we were supposed to have meetings and try to come to some kind of an agreement and try to go forward as a group. That was my understanding of the paragraph. And I think that we did that. We tried to come to an agreement, and we couldn't get sign off on the final piece of legislation that we had all drafted together. And so I don't believe that there was any other legislation that we were ordered to try to even consider or discuss.
Thank you. Ms. Norton, returning to your testimony in the prior case, 2012, 2022-00096. You indicated that you had the overall responsibility to ensure that Kentucky American operates in a manner consistent with the Clean Water Act and with all relevant state laws and regulations governing the provision of safe, adequate, and reliable water service to its customers. Is that correct?
That's correct.
And you still stand by that statement of responsibility in this proceeding?
I do.
Okay. What is Kentucky American's percentage of water loss due to line breaks and leaks?
I can't tell you exactly what it is this month. It's somewhere around 13%.
And not necessarily for this month, but overall and subject to tech check, would you agree that it's generally below 15%?
Yes.
And is it consistently there, below 15%?
I haven't looked at the month-by-month numbers. I would say that the rolling 12-month average is consistently below 15%.
Is it the intent of Kentucky American to provide safe, adequate, and reliable water service to its customers for the next 5, 10, and 20 years?
Yes.
And would the provision of that service over those periods necessitate regular and periodic maintenance of Kentucky American system?
Yes.
And wouldn't that maintenance include the repair or replacement of the components of Kentucky American's distribution system, including water mains?
Yes.
And in this application which you've signed, Kentucky American is seeking a distribution system, and you'll have to correct me if I'm wrong here. It's either infrastructure or improvement charge, DISIC. What is the preferred name in the application? Is it infrastructure charge or improvement?
I thought improvement.
Okay, you thought improvement. I thought
Gary
improvement
Verdell
too.
is the person who provided all the testimony on that, so he could go to the specifics. We refer to the acronyms a
As
lot.
DISIC.
Yes. As-
And excuse me for just one moment.
This one, don't touch this one, don't touch that one.
I've just got a few follow-up questions, excuse me, confirmed with council. Regarding the affordability study, how many meetings did you attend with regard to that collaborative?
I would say over the 2.5 years that I've been here, 2 meetings for sure, potentially 3. I can't recall specifically how many meetings I attended. I believe I attended one early on and 2 later.
Okay, 2 meetings for sure, possibly 3. And would you have the dates of those meetings when you were in attendance, if you could follow that up with a post-hearing response?
Yes.
Okay, that would be appreciated, thank you. And Ms. Norton, we discussed earlier the encouragement to be a leader in regional water planning. Is Kentucky American Water actively seeking opportunities to supply wholesale water to utilities?
When that makes sense for different communities, that's something that we do, yes.
Does it currently make sense to be providing that? I mean, in the current conditions? I guess what I'm trying to say is, are you actively seeking those opportunities at this time?
We don't have someone out going and meeting with people saying we'd like to provide you with additional water. At this point, we don't have a person in that type of a role, but we do have a lot of contacts through the different communities, and through the course of conversations, we've had a few communities that have actually expressed interest to us and concerns if there's a potential drought situation that they might need additional water. So we have those conversations at that time.
Are you actively seeking, well, let me rephrase that. You do currently have some wholesale water supply contracts with communities.
Yes,
is that
we do.
correct? And are you actively seeking to increase that wholesale water supply in those areas that you're currently serving?
I would say that we have conversations, ongoing conversations with those communities to see what their needs are going to be. And if they have additional needs, then we want to be that supplier to provide that additional water. We wouldn't want them to go someplace else. But we're not actively going out trying to get them to buy more water from us.
But you're in the position to provide additional water were they to need it.
In some areas, yes, we are in that position to be able to do that.
Okay. No further questions at this time, Your Honor. Thank you, Ms. Norton.
We're going to,
Oh, yeah, except for the confidential, excuse me. I apologize. Your Honor.
we're going to take about a 10-minute break. You're going to come back and take the stand, and then we'll let the other interveners ask you questions. So with that, we're going to adjourn for 10 minutes.
Me too. You were ready.
Yes. And it's
Okay.
yeah, let me keep save us from having to go confidential.
Okay, sure.
No one gets to do that.
We're gonna ask if they decide.
That's were there other issues?
Advised that we have.
Jerry,
Sure.
do we need to be on the record for you to
Yes,
say
Yes,
this?
yes,
Okay.
we are. Mr. Richard?
Thank you, Your Honor. Your Honor, when this hearing was originally scheduled, it was scheduled for 10 a.m., and the company, in compliance with the Commission's order, published notice stating that it would start at 10 a.m. At the party's request, the Commission moved the hearing back to 9 a.m. We have a member of the public who relied upon the published notice and arrived at 10 a.m. The hearing had already begun, and it may be appropriate at this time, in order to allow her the opportunity that the Commission is going to provide to the public to make a comment, to allow her to make a brief comment regarding the rate case. Ms. Mitchell?
Somebody close the back door.
Welcome, Ms. Mitchell.
Can you hear me?
Yes.
Okay. I'm Pam Mitchell from Lexington, Kentucky. And in the past 6 years, the city of Lexington has had a 71% increase in the water rates, as you well know. And I feel that this, and it is excessive, and the 17.6% increase that Kentucky American Water Company is requesting this year is also excessive. The facts do not support this increase. And I just hope that you turn down the request. Thank you.
Thank you. Any other members of the public wishing to speak? If not, we'll go back to our agenda and ask Ms. Norton to take the stand again. You have remained under oath and continue so. And Mr. Richard, you have questions?
I believe Mr. Barbary is next in line.
I apologize, Ms. Barbary.
That's okay, Your Honor. Good morning, Ms. Norton.
Good morning.
I have a few questions for you. The Attorney General's office was asking you all about possible future expansion plans. From a general standpoint, how would that generally work with relation to your ratepayers paying potentially for the cost of that? If this in any way at all involved the KRS-2 plant?
Are you talking about an
And
acquisition?
if you had a future acquisition involving a facility that you all do not have now, but it had to involve the KRS-2 plant for some reason, how would that work from a cost standpoint?
We haven't approached that subject, so I can't really answer exactly how that would be worked out. I would anticipate that we would evaluate that system similar to all the other acquisitions that we do. We would pay them a fair price based on their rate base for their system, and then we would decide how that was recovered from the other customers or from all of our customers. We are on single tariff pricing going forward.
Do you all feel like you have the ability to use KRS-2 as a platform for additional expansion?
I think that it's part of our system, part of our toolkit, if you will, that we bring to the table. And so, yes, I think that that as appropriate, that we would use that as a resource.
You were asked about the wholesale water contracts, and I guess my understanding is you have indicated that there's been some discussions primarily with respect to the ability of some other water companies to potentially use that as a source during the event of a drought.
That's possible, yes.
How would that actually work as a practical standpoint if you all offered a wholesale contract to another company where the assurance was they would have extra water during a drought scenario?
The contract language, we haven't worked through that because we don't have that type of a contract. There are many different ways that you can approach that situation. And one of probably the most prudent way would be to ensure that our customers had the water they needed first, and that we would only provide any additional amount that we had to the other customers through the contractual language.
Would it surprise you to know that LFUCG's personnel were left with the impression, after having multiple discussions regarding the billing matter that was discussed earlier this morning, that the decision to eliminate the billing service was made at the American Water Works level?
Yes, that would surprise me.
Why would that surprise you?
That would surprise me because I was involved in many of those discussions with Jane Driscoll and Bill O'Mara, where we talked about the reasons why we had decided to end the billing agreement. We had many discussions leading up to that final discussions, and then in that final discussion, saying that we had decided to end that for many reasons.
Did you, at any point in time, did the company ever survey your customers about the billing transfer and the potential effect that it might have on them?
We did not.
Is there any reason for that?
We honestly we believe that a lot of our customers didn't really even understand that relationship. We had quite a lot of confusion about who do they call for service, who do they call to change their levels of service, just lots of confusion. And also one of the big confusions that we found is that people had a lot of, they just didn't understand when a rate increase was going to happen to them, what that meant to them. So if we filed for a rate increase and it was, say, 10%, that we were awarded a 10% rate increase, they would think that their whole bill was going up by 10%. And it was really just the portion of the water service that was going up by 10%. So we found ourselves continually answering that question. And in addition, there is no regulation on, say, if the sewer bills went up. And the sewer bills, I think previously in the public comments we heard that our rates have gone up about 71%, but in that same time period, the sewer rates had gone up by about 98%, and they've gone up twice since that period of time. So the sewer rates have actually gone up at a higher percentage, and there's no notification of the customers, even though it was on our bill, they didn't really get a notification that those rates were going up or have any opportunity to provide feedback in that. And so they were very confused about what was happening to their bills, and so that was one of the reasons.
Do you have any data that you all have collected with respect to the number of, I guess, confusions regarding this issue?
I don't know that we have any empirical data that we can say that we had X number of customers that complained about that. We have a lot of anecdotal data, and we actually, I believe in one of the data requests that there are several emails from LFUCG employees talking about the confusion that the customers had about service and where they were supposed to call and who they were supposed to talk to about bills and service.
Are you familiar with the formatting of the bills that you all used prior to the billing conversion in, I think it was September 1st or August 31st of 2012?
I'm vaguely familiar because I am a customer.
If I represented to you that it has a separate line item for each LFUCG item that identifies it as LFUCG before the item and then has the amount, would you accept that as being accurate?
I would accept that as being accurate.
Was any consideration at any point in time given to modifying the bill format or the billing process to eliminate any perceived confusion on the part of your customers?
Yeah, we had conversations about could we change our bill to make it so that our customers really did understand what they were paying. Bottom line is most customers write the check, and their check being written out to Kentucky American Water, they didn't really look at a lot of the detail on the bill, but they still had the perception that their bill was much higher for water than what it was. When you talk to people about how much their water bill was, they would say, well, my water bill is way higher than that. And then when you talk through that, about half of that was actually city fees. And so we actually had talked about our only real option we felt like was to actually issue a separate bill. We chose not to do that because billing is not our core business. Billing was a side business that we thought would be a good fit. After a period of doing it, we learned it was really not a very good fit for us or our customers. And so rather than head down the path of us issuing the separate bill so that people were very clear on what they owed, we decided when the contract expired that that was the right time for us to end that agreement.
You all were compensated for providing those services, were you not?
Yes, we were.
Do you have just a general idea of how much a year you all were being compensated by the LFUCG?
I think it was about $1.5 million per year.
I'd like to hand out an exhibit, and I apologize for not having redacted the person's name, so I guess if we put this in the record, possibly we might want to redact the name or address on here. Would you agree that this is the format of a water bill? I guess the date on this one is March 22nd of 2011, that this is the format of the bill you would have used in Fayette County?
Yes.
I'd like to go ahead and enter this as LFUCG's exhibit number 1.
Objection? So ordered.
And I like I said, Your Honor, I don't know that it's not inappropriate to mark out the person's address, at least that's on the bill there. So.
And name.
I'm not sure the name. I'm not that familiar with your open records laws, but I would prefer that both the name and the address be taken off there if that's.
Whenever we've produced this kind of information before, we will redact name, address, and I think even account number and premise number. I think this woman is an LFUCG employee.
She is.
So what you do with her information is fine. But
yes,
from
we would.
American's perspective,
Right.
we would like it redacted.
Yeah, we
since
would
this is
prefer
our
that
bill.
it be redacted.
Yeah, Mr. Chairman, as far as the privacy issues that we've encountered over the years, any personal identifiers that could be related back to that individual, that we would insist that information be redacted.
We concur.
We will enter the redacted exhibit 1 of the CG.
In your testimony, I think it's in your rebuttal testimony, you've indicated that the company saw a nearly 37% drop in the number of shutoffs, and then late fee charges, I'm assuming that means dropped 16%. In a supplemental response, could you all provide any data you all have in support of that number, those numbers?
We did not, but we do have data.
Right, if you could provide that as a part of a, yes.
I have some graphs right here that
Okay.
show very clearly that information.
And does it have the dates that the percentages are based on?
For the number of shutoffs or the reconnect fees?
Yes, both the 37% and the 16%.
By month, I believe.
What's the earliest month on there?
The earliest month on there is January of 2012, I believe.
Okay. So, Lindsay, do you all want that in the record now or as a supplemental?
The graphs that she has,
Yes.
it doesn't matter to me. It's your cross. If you want to ask her about the graphs, we'll be glad to pass them out, and you can, or we can provide them as a hearing.
Why don't we
later.
just do it as a supplemental hearing
Okay.
response?
Okay.
Could you explain all the data, and I may have asked this already, and I apologize if I did, but could you explain all the data you have available which supports your statement and your rebuttal that your customers were routinely confused about their bills under the old billing system?
Again, I don't have any specific numbers, but I have a lot of, we have a lobby open and customers come in, a lot of customers come in every day. And I've heard a lot of feedback from my tellers in that specific department that there's been confusion. I've had customers say to me, since we've ended the billing, that, wow, I can't believe how cheap my water bill is. So that's the kind of evidence that we have, and it's a routine thing. When we actually announced that we were getting out of the billing agreement and that we weren't going to bill for LFUCG anymore, my field employees were probably the most excited. They actually clapped and cheered because they get so many questions, and there's just so much confusion that's brought to my field employees that they were very relieved to find out that that was ending.
Is it your position that you would have had the ability to continue providing the billing for Lexington despite the December 2011 directive that Mr. Baker discussed earlier this morning?
I believe that we had made the decision before the company made the final decision to not do billing any longer. We had made the decision and had actually notified LFUCG prior to the time when the company said you shouldn't do these anymore. And we had had discussions. I first started in January of 2011, and that was one of the first items that came up for discussion when I came there, because we knew that the contract was getting ready to expire, and it was a time for us to really talk about the benefits of the contract and the challenges of the contract. And we talked about that right away when I first came there. And so we were already having those discussions before we started seeing the emails from David Baker and others in the company encouraging us to get out of those contracts.
Now, I'm assuming those discussions you're referring to right now were internal discussions?
Yes, they were. They also were related to the 2010 order and the way payments were applied to the bills, because at that time our customers became even more confused because they couldn't be disconnected anymore if they weren't paying their water quality fees or their landfill fees. And so when they would get a disconnect notice in the mail, the amount on that disconnect notice would be different than if they came into our office and said, how much do I owe on my account? Those two numbers were very different, and so they were very confused by that. We got a lot of questions in that way as well, and that all happened about the same time that I came here, and so it was becoming even more confusing for our customers, driving us further down that path.
You were, there was a reference earlier this morning to a email. I think it's PSC staff number 2.
Yes?
Looking over this email, is it your understanding that you generated the original email?
I didn't generate the original email that says subject RE forward nice win for our clients. I did not generate that email.
Okay, I kind of skimmed through the record. I was unable to. Do you know what email that's referring to?
It's referring to an email that we got from another state, from California, a contact that they had.
Do you know what the nice win was?
It was the LFUCG billing contract for Greater Cincinnati Waterworks.
I'm sorry. What?
As I recall, and I don't have the details right in front of me, the consultant that was working with Greater Cincinnati Waterworks that had helped them obtain the LFUCG contract had sent an email out to a group of people saying nice win for our clients, because they had helped Greater Cincinnati get the contract.
So the client was Greater Cincinnati Water, as far as you know?
As far as I know, that was my understanding.
I have no other questions.
Sizemore?
Good morning, Ms. Norton. Could you tell us roughly how many of your total customer base lives at 100% of the poverty level?
I'm sorry, I don't know the answer to that question.
Would you be surprised if I told you it was roughly 20,000?
No.
That would
Unfortunately, I would not be surprised.
About 17.5% of your customers live at 100% of the poverty level. Would you also agree that 100% of the poverty level is probably an outdated measure?
I don't know when that was updated, so I can't speak to whether it's outdated or not.
Is it true that probably many more of your customers are living in poverty at a different measure, 110% or 120% of that level?
I would expect that to be the case.
Would you refer to the rebuttal testimony that you filed on page 1 of that? There was a question on line 15 that says, what are your comments on Mr. Birch's testimony? And that being Mr. Jack Birch's head of Community Action Council. You state in lines 18 and 19 that Kentucky American shareholders have made significant contributions to low-income assistance programs over the years. Now, you were referring to Help to Others, correct?
In part, yes.
And that's abbreviated H2O. And what else were you referring to?
Any other programs that we might have provided assistance to help low income? We do some things with Habitat for Humanity. We do things with God's Pantry. We do a lot of different. We have a lot of different donations that we do to help people in any way that we can.
According to your testimony earlier, you stated that Kentucky American Water is performing well, and you said we're doing a great job. Is it true that your contributions to Help to Others has not really increased in proportion to your rate increases?
I don't know the history of those increases or the percentages of those increases.
Well, according to
we don't. Those donations don't come from our rates. Those donations come from our shareholders.
They come from your shareholders, correct. According to Mr. Birch's pre-file testimony, Kentucky American has contributed $50,000 in 2008 and again in 2009 to Help to Others. And from 2010, including 2011, 12, and 13, the amount has been $60,000 per year. Does that sound right to you?
That sounds correct.
Okay. And did you have any conversations with your predecessor, Mr. Rowe, at the time you took over as president regarding his philosophy with regard to Help to Others?
Not specifically that I recall having a specific conversation with him about that.
Would you be surprised if Mr. Rowe's position was the $60,000 was as much as H2O will get?
I really can't say what he... I can tell you that we've made efforts since I've been here to really increase the amount of publicity and information in our bill inserts to try to get our customers, because that's really, it's supposed to be a customer helping customer type of program and asking them to make donations, and I don't know the percentage of that, but I can tell you...
That's part of it, but it's primarily a shareholder contribution program, correct? That's what you just said.
Well, the $60,000 that we put in, yes, is shareholder contributions.
And is your policy that it's not going to increase more than that?
We don't have a specific policy, I would guess. So,
are you open to increasing it after this rate case?
I think that we could have discussions about that, but again, I think that we do a good job at this point of making donations to the cause, and we'll continue to look for ways to work together and try to increase that number in various different ways.
Going back to your comment of significant contribution that you made in your rebuttal testimony, do you know how this contribution compares to Kentucky American's earnings last year?
No, I don't.
Or American Water Company's earnings last year?
I don't specifically know how it relates. I know it's a small number compared to those earnings, but I don't know that that's
I'm going to pass out,
relevant.
it's an editorial from the Lexington Herald where it talks about some earnings from Kentucky American Water, and let me look at it.
Thank you.
The Lexington Herald, in its editorial on May 23rd, 2013, reported that CEO Jeff Sturba said, on a compounded basis, our annualized earnings have increased by 14% from 2010 to 2012. Would you say that's correct? Can you confirm that?
Jeff Sturbis said that. I would say it's correct.
Do you agree that?
There's no guarantee the Herald Leader got it correct.
But you agree that the company's contributions from 2010 to 2013 for H2O have increased by 0%. Is that correct?
As a specific line item, I would say that's correct.
Does anyone at Kentucky American Water communicate with Community Action Council on a regular basis to keep track of the number of persons that H2O helps each year?
Yes. I believe that we get a quarterly report from CAC
And someone
that talks about that.
tracks that, and who is that person?
I believe it's Susan Lancho, but I'd have to confirm that.
Have you looked at that data yourself?
I've looked at it within the past year. I've looked at that report.
Would you agree that the number of the families and the number of customer families that H2O has helped each year has decreased since 2010?
I don't remember the specifics of the information to be able to say that that's the case.
If you turn to your rebuttal testimony, page 2, the question at line 4 stated, is Kentucky American Water still willing to provide its low-income customers assistance? And you stated that it was your understanding that during the 2010 rate case, Kentucky American Water committed to work with CAC to promote legislation that specifically allows some form of discount for low-income customers. And then you went on to state that Kentucky American Water believes that such legislation is the best and most direct way to provide assistance to low-income customers. Do you still believe that?
Yes, I do.
And how did you arrive at the belief that legislation was the best and most direct way to provide assistance to low-income customers?
Based on the history of asking for a low-income tariff in previous rate hearings, and the decision that that legislatively that wasn't appropriate to do until we got legislative approval. I believe the other utilities have the ability to apply a discount. The water industry, the water business, does not have that same ability to do that. And so we wanted to have the same ability that the gas and electric companies have to be able to do that discount. And based on all the information that I've seen about rate structures and the potential pros and cons of the different rate structures, I firmly believe that being able to discount a customer's bill on the fixed portion of their bill is the most direct way to help the low-income customers. Otherwise, you end up helping customers that don't need the help. And so in order for all the help to go to the right people, I think we need this legislation that will allow us to put that discount in that appropriate rate structure. And that's what the legislation that we drafted as a group intended to do. But unfortunately, we knew that one of the most major interveners, which was the Attorney General's office, didn't feel that they could support that approach. And so that put us in a difficult situation.
What you stated about the legislation, I think many of the parties agreed with you about. But did you have some reason to believe that there would be any chance that legislation like that would ever be passed in this state?
I do believe that.
How did you believe that?
Because we have to believe in our political process, and I have hopes that our elected officials would see the importance of doing this. I think that it's unfair that customers are treated differently for their water service than customers are for electric and gas. Frankly, we don't like to, but we can live without electric and gas. Water is a necessity, and I think that our customers should be provided the opportunity to have that discount if they can't afford that service.
But given the fact that low-income customers would have gotten a discount with this legislation and others would be making up the difference, and that this would really pretty much be applicable to the Lexington area, why would you think that that legislation would have a groundswell of support?
I don't know that it would have a groundswell of support. I think it would have taken a lot of work on our part, and the fact that that we knew that we didn't have one of the key interveners. One of the first things that our legislators will ask when we go to them with proposed legislation is, where does the AG stand on this? Where does the PSC stand on this? And so in order for us to be able to have any hope of passing it, get any support, we knew that we had to have those key players.
Isn't it true, Ms. Norton, that the final order in case 2010-00036, your last rate case, on page 75 stated that CAC's proposal should be further studied and additional customer data gathered to permit a thorough assessment of the proposal's potential effects? And I'm going to hand you out. I really should give you a copy of the pages.
I have.
Do you have that?
I have the
Still
order.
has the 2010 rate case order.
Would you
Order.
please then turn to page 75. Do you know what CAC's proposal that the commission is discussing there is in that case? What they're referring to, what the commission is referring to?
It doesn't come right to my mind, I'm sorry.
The commission was referring to CAC's argument in that case to restructure your rate design to create a graduated tiered structure or inclining block structure. Does that sound familiar to you?
Yes, that sounds familiar.
So you would agree that this was something that was supposed to be studied according to the last order?
Yes.
Okay. And would you explain the company's study of this proposal that allowed you to reach your belief that legislation is the best?
Well,
and most
I'll
direct way?
object. That question assumes that it was Kentucky American's obligation to study a proposal that had been submitted by the CAC. The question assumes that it was Kentucky American's. The language of the order speaks for itself, but I don't think that's a fair assumption of that language. CAC made that proposal in that case. CAC has the ability to study that. It's a fair interpretation of that order.
I believe it's pretty clear from the interpretation of the order that the company was supposed to study what CAC had proposed. What you're saying is, have you all studied
I've
the
looked.
proposal to create a graduated tiered structure?
I've looked at the American Water Works Association manual, the M1 manual on rates, and you know, they raise some of the same concerns. They have discussion on several different rate structures in that manual, and the issue with that is that it really doesn't target just the low-income customers. Low-income customers are sometimes a single person on a fixed income, or they may be a family of 6 or 8. And so the amount of water that they use varies very dramatically. You may have someone who only comes into town every once in a while, and they're very rich, and they may be able to take advantage of that. And so it's not just targeting the low-income customers. And so that's why we didn't, based on the information that we've read and the things that we've seen, we didn't pursue that any further.
So you didn't gather any data or make any thorough assessment, is what you're saying?
We did pull some data together about specific zip codes, I believe. I can't remember all the specific information that we tried to pull together. And I think there was some data that we had asked for from CAC that, we looked at a few different alternatives, but we kept going back to the legislative option as being the fairest and most direct way to help these customers.
The order also at page 75 found merit to CAC's proposal to undertake a collaborative study on the affordability of water, correct?
Yes,
And you took part in that to some extent, correct?
to some extent, yes.
Isn't it true that the commission found in that and stated in its 2010 36 case that the collaborative study should consider all potential regulatory and legislative solutions?
Yes.
And in fact, were there, let me rephrase that. Do you know how many meetings you attended?
No, I said earlier at 2 or 3 meetings.
You were at the first meeting, correct? And that was on February 9th, 2011. That's what.
I believe so. I was at an early meeting in February or March, I believe, right after I came here.
And that would have been February 9th, 2011. That was less than 2 months after this order came out in this case, correct?
Yes.
Because the order came out in December of 2010. Okay, so in your rebuttal testimony on page 2, line 22, you stated that at the collaborative meetings, Kentucky American Water explained that a legislative solution is the best and most direct way to provide assistance, correct?
Yes.
Now, in fact, at that first collaborative meeting, which was less than 2 months after the order, the company was already pretty much saying it was legislation. It had to be legislation, correct?
That was our belief at that time.
So really, there wasn't, the other alternatives hadn't been addressed at that point, correct?
I believe that that's probably correct if that was the first meeting. And there were several subsequent meetings where I believe the interveners were there, so those other options could have been discussed.
But the first meeting, it was pretty clear that you were there, that Kentucky American wanted a legislative solution, and that's really all they were interested in talking about, correct?
I would say we believed walking into that meeting that it was the best option. I'm not saying that that was the only thing we were willing to talk about.
There was a second meeting on March 29th, and you were not at that meeting, I don't believe.
I don't believe I was.
And then another one on September 1st, 2011. I don't believe you were at that one. The fourth meeting was on December 16th, 2011. And I don't know if you were at that meeting or not. You don't remember?
I don't
either.
recall being at that meeting.
Were you briefed on that meeting? Do you remember?
I believe that I was told at that point that the legislation that had been drafted at that point was not getting the support that I think the Attorney General had raised serious concern about taking that path at that point.
Is it true that after that December 16th, 2011 meeting that, or were you told that John Mark Hack had committed to pursuing this with the legislature?
I was under the impression that John Mark Hack would drive a legislative, or at least would help facilitate a legislative solution, and I thought that was the path that we were headed down until after that December meeting. And then at that point, again, we knew it wouldn't go anywhere if we didn't have support.
In your testimony on page 3, your rebuttal testimony, you stated, starting at line 16, when it became clear that that was not going to be the case, the full support of the legislation in the line before is what you're talking about. Neither CAC, the Attorney General, nor KAW took meaningful steps toward having the legislation introduced in the 2012 General Assembly. Isn't it true that Kentucky American Water was told that, of course, CAC could not introduce legislation, that CAC is a nonprofit corporation? Do you remember that?
I don't remember that. I wasn't at the meeting where we discussed the 2012 General Assembly.
And John Mark Hack had committed to take the lead at that meeting. And then, isn't it true that there was not another meeting for a year?
I would say that is true, that there was a long period of time before there was another meeting, because for various reasons. Part of the reason was that that we felt like there was no support for the path that we felt was the right path to take, and we did not feel that the rate design that was brought up previously was the right way to go. And besides, that would happen in a rate case if we were going to take that initiative. But more importantly, there didn't seem to be any reason. I felt like John Mark Hack, he left at the end of sometime in March or early April of 2012. And I picked it back up later in the year, thinking that we needed to give it one more try as we approached the time of the General Assembly meeting again in 2013. And so we had a couple of follow-up meetings, one of which I think we talked about this M1 manual from AWWA and the different rate designs and the things that could be potential solutions in that meeting, but it all hinged on having that legislation and having that ability to provide that discount.
Kentucky American Water called a meeting on December 8th, 2012, correct?
That sounds correct.
And you were present.
Yes.
And that was really after, like you've agreed that communications were minimal the previous
Yes.
year. And that meeting was held how many days prior to your filing this rate case?
Probably approximately 20. However, I would say that was more coincidental. We felt like we had done everything that we were supposed to based on the order in 2010. And the timing of this meeting was much more around the legislative session than it was around this rate case. We had filed all the reports we were supposed to file, and I believe in the order it said to talk about our discussions or progress. I can't remember the exact verbiage, but we felt like we had met our obligations. We had met with the group numerous times, and it just didn't seem that the group as a whole was driven to move forward and make this happen. So we felt like we had done everything that we were obligated to do as a part of the order. So the timing was that, look, if we don't do something in December, we're not going to get anything in the 2013 General Assembly either.
And that meeting was on December 18th, 2012, correct?
That sounds right.
And the rate case was filed December 28th, 2012?
Yes.
And the notice of intent was filed November 29th,
Yes.
2012?
Mhm.
Okay. So at this meeting, which was 10 days before you filed your rate case, you passed out the AWWA manual, Chapter V4, right, on low-income affordability?
Yes, and that was based on a conversation with David Spinard. He had seen this manual and thought that it warranted discussion.
And isn't it true that in the previous 4 meetings that happened between 2011 and the last meeting in December 2012, both the AG and CAC always made it clear they wanted to explore all affordability options. Isn't that correct?
I was not at those meetings.
Would you agree that, were you briefed about the meetings that we were interested in discussing all the affordability options?
Specifically briefed about specific things, maybe or maybe not. I do recall that you guys had asked for different options. It was in the order that you wanted to talk about different
In the
options.
meetings you attended, I'm sure you can agree that that it was clear that both the AG and CAC wanted to explore different options.
Okay.
But CAC was generally in support of the legislation, isn't that correct?
Yes.
And isn't it true that Mr. Birch agreed that if it got introduced, he would do what he could to educate and
Yes.
discuss this legislation under the constraints that he had?
Yes, he made it clear that he did not want to take the legislation forward and be the person taking it to a sponsor. But he said that once we did that, he would support it.
And he would try to educate about the legislation, correct. I want to refer back to this editorial
Yes.
that the Lexington Herald printed on May 23rd, and it states that Kentucky American has enough excess capacity that it is negotiating agreements to sell water to Nicholasville and Paris. Is that correct?
No, that is not correct.
So that's just completely not correct.
That's completely not
But
correct.
you may be negotiating with other cities, correct?
To my knowledge, we are not negotiating with any cities right now to sell additional water.
If you were able to sell additional water to other cities, how would that revenue offset the expenses you're asking to be passed on to customers?
Well, any water that we sell comes at a cost because there's a cost to produce that water through electricity, chemicals, power, all those kinds of additional operating expenses that come with that. And we do a cost of service study so that we see what it would cost to sell. So we as part of this case, part of our tariffs, the sale for resale customers are, we determine what that cost of service is for them. And so that's how those rates are offset, by what it cost us to serve them.
Is there any opportunity for any of this revenue that you might be able to get if you were able to sell water to other customers or other municipalities, et cetera? Would there be any opportunity for that revenue to help your most vulnerable customers, the low-income customers?
Again, that goes to our operating cost, and the help to the low-income customers comes from our shareholders, so it's a different.
But as the company makes more money, the shareholders make more money, is that correct?
It's not a one-to-one correlation, but yes, that does occur.
Thank you, Mrs. Skidmore.
Thank you, Your Honor.
Richard?
Good afternoon, Ms. Norton. How are you
Afternoon.
today? I'm going to skip around since a lot of these areas have already been touched upon, but does Kentucky American Water Company currently bill for American Water Resources Home Services Program?
No, we do not. And I believe that's American Water Enterprises, not American Water Resources.
Okay.
But we do not. It's a non-regulated business, and
Is there any plan to
No.
do billing after the business transformation is complete?
no, that would be against our affiliated agreement.
Do you know, has there been any specific study done to determine the actual cost of billing for third parties? And by that I mean actually getting down and allocating the cost of particular transactions, part of the cost of a water end and part of the cost of a sewer end.
I believe that in Melissa Swarzel's testimony, that she talks more about the cost and the cost offsets of, I know that we eliminated a position, but as far as the specific details about the costs, that the operating costs and things like that, you'd have to ask her.
In terms of doing the actual cost allocation for particular functions, let's say, for example, meter reading, since that function would be, if you were doing third-party billing, that would have to, a portion of the cost would have to be allocated to for lack of a better word, the sewer business. You allocate your cost now for your Olenton treatment area because you provide sewer or wastewater services to Olenton. Is that correct? Or you try to?
We try to in a general way.
And recognizing just that general principle, has Kentucky American at any point in time prior to the termination of its contract with LFUCG gone back and done a detailed cost of service study just to find out how much it costs to actually bill for, or what its total services that it provides, what the cost of those services were?
Kentucky American didn't go back and do any kind of specific study. I believe that there were some general American water studies that were done for specific kind of cost centers, like the call center and things like that. But it's very hard to equate the amount of time and effort that was spent in the different departments. For example, in the rates department, every time they raise the sewer bill or the landfill fee or the water quality fee, our rates department has to do testing because anytime there's a change to that. And so keeping track of all of that was not something that that our accounting just didn't go to that level. So there was no way to really determine the all-in cost of doing that.
Do you know, and this question encompasses not only the time that you were at Kentucky American, but back to the time when Kentucky American began billing for LFUCG. Had anyone at Kentucky American looked at that component and tried to break down the cost to make a determination whether the revenues coming in met the cost that should have been allocated to the third-party billing services?
I don't know if there was a specific study done before I came there, but again, I know there were specific things that we could point to. We knew that we had a full-time person that dealt with that. We had various other costs that were included in there that we could point to specifically. Melissa's got all the information on those specific costs. But as far as really drilling down and saying how much time is spent in the rates department doing the testing, my answer to that would have to be I do not believe so.
Okay. You mentioned customer confusion as one of the reasons for the company's decision to get out of the third-party billing services area. Did Kentucky American ever perform any type of customer survey to determine the level of customer confusion or lack of knowledge as to the bill?
No. We had done some surveying to ask customers some of our routine questions, and I can't quote to you the percentages or anything like that, but we had done some surveys to ask customers who provided their water service, who provided their sewer service, and we saw some level of confusion in those answers where people didn't know who provided their services.
And when were those surveys done?
Sometime between when I came here in January of 2011 and the end of 2011, I believe, but it could have been sometime in 2012. Sorry.
Would it be possible to provide a copy of those survey results to the Commission?
Yes.
Let me move on very briefly to the collaborative. There were, based on what's currently in the record, there were 4 members of the collaborative: Kentucky American, the Attorney General, Community Action Council, and Lexington Fayette Urban County Government. Is that correct?
Yes.
Were any other groups made aware of the collaborative or asked to join the collaborative?
Not that I'm aware of.
Is there any reason, for example, given the fact that legislation was at least discussed even at the very beginning when the Commission directed the formation of the collaborative, not to talk to some of the other large water suppliers that are subject to PSC jurisdiction, such as Northern Kentucky Water District?
All I can say is it probably was an oversight. Had we headed down the path of trying to get the legislation passed, I think that would be a natural thing that we would have done, would have reached out to other utilities that would have potentially supported us in that.
Did any members of the collaborative make suggestions to expand the membership, to the best of your knowledge?
Not in the meetings that I was in.
Okay. In the meetings that were reported to you, are you aware of any
never came up.
suggestions there? Okay. Did anyone take minutes of the meeting on Kentucky American's part?
I took some notes at the couple of meetings that I was at. We did have our attorney, Lindsay Ingram, there, and I would assume
Let
Lindsay
me
took some
phrase it
notes.
this way. Were there formal minutes of the meetings? Okay,
No.
There were no formal. Would it be correct to say that during this process, there were several drafts of legislation offered that went back and forth?
Yes.
Okay. Do you know if any of those drafts ever found their way into the record of this case?
Not that I know of.
Okay. Do you know if based on your testimony, I interpret it that there was at some point in time a final draft
Yes.
that at least was the legislative solution that the parties at least had agreed in some manner. Can a copy of that be provided
Yes.
for the record? In terms of the drafts of the proposed legislation, was the initial draft drawn by Kentucky American?
I can't answer that question. I'm not sure who drafted the initial one. I assume it was Kentucky
Well,
American.
let me put it this way. Were alternative drafts, or did any parties other than Kentucky American offer drafts or proposals for legislation?
My understanding was, based on the emails that I did see, was that there were redlined comments on the initial draft. And so I think it went through a process of let's put something on paper, and then people provided their feedback and comments on that initial legislation. I don't recall ever seeing a separate piece of legislation that was put out there.
In your rebuttal testimony, well, first let me ask, to the best of your recollection, when did Kentucky American make the decision to terminate its billing contract with Lexington Fayette Urban County Government?
It's hard to say when the actual decision was made. We had a lot of conversations leading up to it. I would say probably the May to July timeframe of 2011, we made the final decision that there was just no other alternatives that we felt were better than terminating the contract, which ended, I believe, on October 1st.
And can you recall when notice was actually given to Lexington Fayette Urban County Government that the contract was going to be terminated?
The official written notice, I believe, was given on October 3rd.
And did Kentucky American provide unofficial notice prior to that time?
Yes, I had had conversations with Jane Driscoll, and Keith Cartier had conversations with Bill O'Mara.
And when was to the best of your recollection, that unofficial notice given?
I would say in August or September, but I don't know when that unofficial notice was.
In your rebuttal testimony, you indicate that terminating the billing services to Lexington Fayette Urban County Government resulted in, I guess, a savings, would that be the correct term, of $254,625?
Yeah, those are those direct costs that I talked about, the position that we eliminated by getting rid of that. And again, Melissa can answer those questions
Okay,
better.
let me ask this. Your reliance is upon Melissa's testimony, is that correct?
As far as that basic dollar amount, yes,
Okay,
she's
so
the one who had the details.
So if I were to ask questions, I should direct them to her?
Related to the specific cost details, yes.
Okay. In your time at Kentucky American, was there any discussion about whether the Kentucky statutes required Kentucky American to maintain any type of separate accounts or cost allocation manual for its billing procedures for the third-party billing it did for Lexington, Fayette, Urban County?
There were no statutes that I was aware of.
Let me turn very briefly to Owenton. And during the proceeding on the Northern Division Connection project, there was some discussion about the cost incurred to make necessary improvements to the Owenton system. Do you recall some of that discussion during the last case?
Yes.
And I believe, if I'm not mischaracterizing the record seemed to suggest that when Kentucky American purchased the Owenton system, it was aware that there were some deficiencies in the Owenton system that would require an infusion of capital in order to bring it up to appropriate reliability standards. Is that correct?
Yes. Part of our due diligence would be to determine what capital projects absolutely had to be done right away and get as good a feel for the system as we possibly could based on that due diligence review. And look, once you start operating a facility, then you see the whole big picture.
And my next questions are not related specifically to Owenton, but just in a framework on how the water utility views its role as a regional water supplier. Let me go back and ask so I can make sure I understand. When the term regional water supplier is used, does Kentucky American look at that as simply being a wholesale supplier to the various water systems that are in central Kentucky?
No, not necessarily.
Okay, so you're looking at it also in terms of the acquisition or expanding retail service beyond the areas you currently provide retail service to?
Yes.
To the extent that you acquire a system such as Owenton that would require capital infusions, would you agree that if you're using a unified rate structure, some of the costs that are going to be incurred to bring the acquired system up to appropriate and acceptable standards will have to be borne by existing shareholders that are your core group as opposed to the group you're acquiring?
You mean existing customers?
Yes.
Yes.
Okay.
Yes, I would agree with that, and that's part of why you have single tariff pricing. If you have to make a large capital investment in a small system, that's the benefit to systems to regionalize because a few customers handling the burden of a big capital investment to make sure that their water is safe and reliable, it's a huge rate impact for them. When you spread it over many customers across the state, a lot of times it's a penny or less per month, depending on the level of that investment.
So you would agree that using the unified rate structure, those customers who are part of the acquired system are going to benefit because their system, their quality of service will improve and there won't be a dramatic increase in the cost of service. The rates will still be affordable.
Yes, I believe the rates would still be affordable. How those rates would change based on where they're at could be part of the problem. Maybe their rates are so low right now that they haven't made some investments that they need to, and they just don't have the ability to do that. Sometimes their rates actually go down as a part of being part of the regional group.
Okay, so but the acquisition is therefore a benefit to those acquired customers because they get better service.
Yes.
And presumably they get it at least affordable rates.
Yes.
If the assumption is that to bring the individually acquired system up to standards would require much greater increases than if they're part of that much larger system.
Yes.
And would you agree that the shareholders of the utility benefit because by placing additional capital to make the necessary improvements to meet its obligation as a utility, it's expanding its rate base and thus has a larger amount upon which it can earn a return?
Yeah, I would say that growth of the business, good growth, prudent growth, is good for the shareholder as well.
Okay. My next question is, what about the existing customer? If the existing customer is not going to see any change in its service, and because of the expansion of the system and the infusion of capital, it may see an increase in its rates, is there, what benefit does the existing customer get out of the growth and expansion?
Well, any capital investment that we make in any part of our system is spread out over all the customers. So in the current example, if you look at, if we make a large investment in Lexington, for example, we built the new plant, put that new plant online in 2010, and the customers of Owenton have been paying for that plant ever since 2010, but they didn't get any benefit from that plant because all that water went to Lexington and the central Kentucky area. So it's kind of a trade-off. Everybody benefits by the entire system being more sustainable, and when our shareholders benefit, then the availability of capital is more, so we can make more investments into the system that are necessary so that we don't end up in a crisis situation and we can continue to maintain our system at a high level.
Would you agree that in terms of the benefits and the risk that are going to be borne, the existing shareholders will, perhaps only if the costs go up a few cents, it's deemed to be an acceptable balance that the public benefits through additional customers getting higher quality of service, everyone, the public benefits at large?
I would say that yes, they benefit at large.
Okay. But in terms of the company itself, to the extent that it is adding capital and it is allowed a reasonable rate of return through these acquisitions of systems that require capital, what risk does it have in this process? What cost is it when it acquires that system?
Anytime you acquire a system, there's some risk involved there because you don't know everything about that system. You may not even have a lot of the municipal systems that we've looked at or talked to. A lot of times they don't have very good records of their system, and so you don't truly know what you're getting, and so there may be additional capital needs that you didn't know about. The operating costs could be different than what you expect, and so you try to balance that and really just dig in as deep as you can and try to play out all the scenarios. But there is some risk that system won't operate at the level that you think it will, and so therefore it would degrade your return.
Well, assuming that you do your due diligence and you know all the problems that are with the system, at that point, isn't the risk somewhat minimal? I guess the question I'm asking is that based on the discussions that came after the Owenton order was issued, some people argued that the Owenton ratepayers got better service. Kentucky American got a larger rate base. The customers in the Central Division were left with potentially at least absorbing some of the cost related to that investment. And the question is why it didn't appear that the company had any actual money in the game making that contribution. And maybe that picture is wrong.
I guess I'm not sure what you mean by the company didn't have any money in the game. I mean, the company paid a certain amount to purchase the Owenton system. And my guess would be that it was probably a penny or less on the customer's bills here in Lexington per month. So I think the company did have skin in the game. I mean, it's our reputation at risk if we don't do a good job operating a system, and so I think it's really important that we're careful in the systems that we acquire. But I also know that many of the systems that we can acquire to grow or try to regionalize are some problem systems, and even the commission at times has said, that there are some systems out there that would be much better off to belong to a larger organization such as Kentucky American Water. And we want to be that solution or that resource, but we also want to be very careful in how we do that. I believe the Owenton acquisition, based on everything that I know, was a good thing to do for all of our customers. And I believe that the Northern Connection that we're doing right now, that we're asking to be paid for across all of our customer base, just like all of our other capital improvements, is good for all of our customers. As part of that, we're going to reduce our operating costs in the Northern Division fairly dramatically, and the Lexington customers will benefit from that as well. So I think that it's an important trade-off, and making that investment is good for the state as a whole.
I think I have just one more question. It goes back to the unified rate structure. At least prior, or even now, since the Northern Division connection is not yet complete, the two systems were separate. And so the argument could be made that a unified rate structure might be inappropriate. Now, Kentucky American is currently using a unified rate structure that the Commission approved. To the extent that Kentucky American were to acquire any other systems that are not physically connected to it, what standard would Kentucky American employ in terms of deciding whether a single unified tariff is appropriate for that acquired system?
My belief is that if we acquired any system within the state, that a unified tariff would be the right way to go. I have experience just from my work in Illinois, where we had single tariff pricing for nearly all of our customers in that state. When you don't have single tariff pricing, it makes the rate cases even more complicated, but the real biggest issue is just that it helps to spread those costs out evenly and make water even more affordable for a lot of different communities, rather than just one specific area of the state.
Thank you. That's all the questions we have this time.
Questions?
Good afternoon, Ms.
Good
Norton.
afternoon.
Following up on the questions that Mr. Wucher asked, and he's making reference to our order in the Owenton case, and although the AG, Attorney General, disagreed with our characterization of their position, we really addressed the Owenton, or we raised two different issues, although they're linked. One was just the ability of the Commission to examine purchases and costs that you all might have paid for the Owenton system. And I guess, and that's one issue, and the second has to do with the unified rate issue. My first question has to do with the notion, do you think that the Commission should have the ability to examine purchases, costs that an acquiring utility such as Kentucky American has on the front end?
I think that the laws differ from state to state on whether that happens. In some states, approval for acquisitions is required. I know that in Kentucky, it's not required. And so until that statute would change, I don't necessarily have a preference either way. I can see why you might want to see that. From our perspective, we would like to know what we're going to be able to earn on before we pay the amount. That can be challenging. But again, it differs from state to state.
So at some level, your last comment, I guess if you're of two minds on it, one mind might be that it would benefit you all to know on the front end if we're going to have any issues with respect to the acquisition on the back end.
Yes.
Okay. My next question has to do with the unified rate schedule, and I guess I'm calling upon you with your experience in other states, and I know you answered that, I guess at least partly, by saying that at least in Illinois, most of the acquisitions, if you will, ended up with a unified rate schedule. Is there an alternative model or method to that allows regionalization of water supply other than with a unified rate schedule, or does it just not make any sense unless there is a unified rate schedule?
I'm not aware of any kind of regional rate schedule like that. I do know that in Illinois they had a special situation where one of their locations purchases all of their water, or pretty much all of their water, and so they rolled them in during their last case to single tariff pricing for all of the additional costs, but they removed purchased water from that. And I'm not sure about all the details of that, but they did do some kind of a modification there based on the purchased water. But they found in the state that it's really helpful to be able to bring a high level of service to all these smaller utilities and the utilities across the company there by rolling them into the single tariff pricing.
In the application, you all indicate, you give some general, the application gives some general reasons as to why it needs this rate increase, and one of them is energy efficiency projects. And I guess my question is, where are you with respect to energy efficiency within your system, and what kinds of projects do you have likely or you're considering at this time?
We've had some audits come in, some different organizations come in and audit us. But Keith Cartier is really the right witness to ask about those energy efficiency projects.
Okay.
He has a lot more detail around that than I do.
Okay, and I should have said, which is obvious, that if you prefer someone else to answer the question, don't hesitate.
Okay, thank you.
In your both your rebuttal and your direct testimony, you talk, and I mentioned this in my question to Mr. Baker about obscuring price signals, and I think you said that ending the billing service with the city would eliminate, or that the billing with the city obscured the price signals. And I guess my question is, in reading your testimony, it seems as if and what you said today, that you're viewing this as being a success, in the sense that you are giving your customers more consistent price signals as to what the cost of water is, and you're seeing results of that in the reduction of untimely paying or cutoffs. Is that all accurate?
Yes, I would say that that's exactly what we've seen. And I think that when there were so many other factors on the customer's bill, no matter how much they tried to reduce their usage, they didn't see that big of an impact potentially on their overall bill. And so we do believe that, and we have the numbers to show that since we since we made that separation, that we've had fewer people have disconnects for non-payment and have paid fewer late fees than what we anticipated.
And I didn't ask this very articulately to Mr. Baker, but my understanding is that there might be, and I'm going to separate it into two different issues. One is just the confusion with respect to multiple charges on the bill, and the other is the actual amount of the bill itself, where it is. I mean, to use an example I think you gave, where it could arguably be double what the actual. Is that accurate? That it's both of those elements?
I think it is both of those elements, yes. And the bill that Mr. Barbary gave us, I don't think it's exactly representative of a typical bill, because it's not anywhere near what the average usage would be, and so the usage difference really skews what a typical customer would see. So I think that when you really look at what the average bill would be, which is more about 4,500 gallons used, it's fairly dramatic.
So is there a notion that because the bill is now smaller, that people, and I guess this is, I'm not an economist, but this is the price elasticity of demand concept, that people may not be as inclined to engage in energy efficiency with respect to this resource because of the lower bill. Is that possible?
I guess that's possible, but I think that they would see this bill reduce more if they were to try to be more efficient in their usage than they would in the overall larger bill. They would see that impact more. I'm not an economist either, but I think that could work both ways for you.
Okay. If I've got specific questions about growth or reduction in demand, is there a particular person I should ask that question of?
Linda Bridwell would be the person to talk to about demand.
It seems like the last hearing we had, as we were going through this process, she was getting questions bounced to her a lot more than we are today. So it seems there's not many so far. So I'm not sure what that means, but it's just an observation.
She's probably taking offense at that.
Yeah. Exactly.
I don't bounce well.
On the Owenton system, one of I think, as you know, the reason why we allowed the extension to the river rather than upgrading the facilities themselves at Owenton was because although the capital expense was higher, there were going to be much greater reductions in O&M going forward, and that, when one looked at lease costs, that's what drove that. Isn't that correct?
That's correct.
Okay. And I know that the extension is not in place yet. Have there already been reductions in expenses at the Owenton system as a result of the order, and what's happened since then?
No, I don't believe there's been any reduction in expenses because of the order. We did have one employee that left the business, and because we know the path we're headed down, we've chosen not to fill that position, and we're filling in with existing employees as we can, rather than hire another person in and then have to let them go from the business later. But the construction on the pipeline is underway, as well as the tank sites and the booster stations, and we see that we should be done by the end of the year, just like we planned.
And I think you indicated that there would be a reduction in employees, and they would not be moved to the central division, if you will. Is that correct?
That's correct. We do have, I believe, one open position at our KRS-2 plant that one employee will move into. I think we have another one that's going to retire, and so through various ways, I think we can get there fairly easily.
There's been a lot of talk about your involvement and who made the decision with respect to the contract with the city. I want to ask a question with respect to the proposal before us, one of the aspects of the proposal before us, which is to change the allocation of customer charges. I think I'm articulating that right, where before it was approximately 3-point-something%, and now it's going up to 6-point-something% because you're moving from a per capita to a per call to the call center.
I'm not sure on the percentages, but that's correct. We did change from a per capita to a per call at the call center.
Okay, and my question is, were you told by corporate that this is what you must do?
They changed the way that they charged us for those services,
And
yes.
You didn't
And
have any ability to say no on that, okay. And is there an actual, I assume there's an actual written contract between Kentucky American Water and American Water?
There is.
And do you know when it expires, or?
I don't. Unfortunately, I'm not familiar with a lot of the specifics in that contract.
Has there been a new contract with Kentucky American Water since you came in January of 11?
I don't believe so.
That's all I have. Thank you.
I have a few. Good afternoon.
Good afternoon.
Ms. Norton, in looking at some of the percentage increases in the application, I was wondering if you have heard from specific customer classes on some of the percentage increases. For example, the residential class, the commercial class, the industrial class has a percentage increase of around 20%. Another customer class is the public fire hydrants, and their percentage increase per hydrant is about $7.46, or about 20%. Have you heard in the industrial class, their average bill increase is around $1,500 per month, if I'm reading that correctly? Have you heard from any customer classes as you've done your public outreach on your rate increase?
I would say that we've of course heard from the residential customers, but not a dramatic amount. We also have a person who spends part-time doing major account outreach, and so he's been very active in reaching out to those commercial and industrial customers to talk with them about the increases, the drivers for the increases. And as you may know, Toyota has done a lot to try to conserve, and so they're doing everything that they can to try to drive their costs down as well. And so I don't think we've had any kind of outcry or outreach from them, and for the most part, but Charlie's been very proactive in getting out and having conversations with them and listening to their concerns.
I believe staff will have some questions later on specific elements of these, but I just wanted to point out that my quick math on the public fire hydrants would be about $100 a fire hydrant per year. And then if you add all the fire hydrants up, it would be just under $700,000. So you haven't heard from
I have not.
people paying the bill for the fire hydrants?
I have not.
Okay. I have a question about expansions. I believe it was the Attorney General who asked about expansions, and you mentioned that you're looking at all over the state. Are you looking actively at other parts of the state?
I'll be honest with you, we had a strategy meeting recently, and had conversations about how could we better reach out to other parts of the state and have conversations. Again, right now, I don't have anyone in the position to be actively out there looking. That's part of my responsibility right now. And I've actually received a couple of calls from different communities that are not contingent or, to the Lexington area or to our current system. And one of them actually was pretty far away, probably 2.5 hours.
Well, that was my thinking. If you think about our state, it's long.
Yes.
And if you ended up acquiring a system, say in far western Kentucky or in far eastern Kentucky, and the vice chairman's question about how you would make a unified rate work if you acquired a system in the farther reaches of our state, that would need to be explored. But I was just wondering how actively the company was in your expansion plans.
Right now, it's not incredibly active, but we intend to pick up that activity going forward. And honestly, it's a similar model to we have in other states where we have places 2.5 or 3 hours away, and it's not as problematic as one might think. And all the customers benefit from that kind of expansion, even being 2.5 hours away, because then my salary is shared between all the customers in all the different areas and all of the people who support, like from finance and external affairs and things like that. Many, many times you don't add any employees at that kind of level or oversight. The employees you're adding are the employees on the ground. And typically you keep the employees that are there because they know the business there. So it's a model that works fairly well.
Thank you. Along that line, Mr. Wucher talked about the Owenton project, and you talked about, there was a discussion about the due diligence and not really being able to know exactly everything you're purchasing. Is there a way to improve on Kentucky American Water Company's due diligence in order to have a better picture of truly what the problems and issues are before acquiring a trouble system? Is there a way to just, I know you're not going to know 100%, but are there ways to improve on the due diligence?
And I would say that we could always improve, and I think my team right now is very strong and motivated, and they're going out in small groups, and so we're getting a cross-section of all the different, we'll have somebody from production, somebody who may have some wastewater experience, somebody from the distribution side, and they go out and we add to our list of questions every time we go, and depending on the system that we're talking to and the level of record keeping that they have, we can adjust as to how intensely we dig into what they have based on what we can see and what information they can provide to us. So I think we can always improve. But you're right, there's always going to be some portion of things that we don't. Many times when we go into a system, the way the plant is currently being operated, it may appear that they're out of capacity or that they're having regulatory issues. And we believe, based on what we see, that we can make changes to help with that situation without making a huge capital improvement. And so there's a bit of risk there. Can we really do that or can we not? And that's why you got to bring all the expertise in.
And I also had a question on energy efficiency, which I'm kind of renaming water efficiency or conservation.
Yes.
On the electric side, the energy efficiency movement has progressed so much that companies tout and take pride in their ability to engage in energy efficiency and actually show demonstrable savings. Mm-hmm. On the water side, I need to educate myself more on this, but you've already mentioned the use of fewer chemicals, less electricity, and I don't know if running the water pumps would be part of that. The Kentucky Water Authority withdrawal fees, operating costs, could all of those be savings, categories of savings, if Kentucky American had a very successful water efficiency program that could be passed on to consumers?
Yeah, there are certain variable costs that you would be able to save on as the water usage goes down. There are certain fixed costs that are going to be there no matter
Yes.
no matter what. So it's a balance between the two. That yes, as people conserve more, then.
But if you have plant and service that's not being fully utilized, and on the one hand, you want to go out and acquire more customers to sell that water and to fully utilize that plant. But on the other hand, it could be considered a savings if you are spending less on chemicals and power and O&M. I just was, and maybe Mr. Cartier can help me understand that better, how the company could come up with an effective and robust water efficiency plan at the same time trying to use plan and service.
Right. Yeah, ideally, like the Owenton situation, if you can invest some capital and reduce your O&M costs a lot and bring more customers on to the same facility that has some capacity, that's a great way to do it because you're saving on those operating costs. And you know, if you're running 3 treatment plants, then you know it's costing more than if you can do it with just 2 treatment plants. But you also have to make sure that you have that capacity for growth in the communities, and so it's a real balancing act. We've done some conservation work, and we're working right now closely with Bluegrass Pride and trying to you know, have them help support the whole conservation message and through workshops and different things to try to really drive that message home, because we want to take care of the capacity that we have. So Keith can probably tell you more about specific savings related to conservation type programs, but you're right. People in Lexington don't think about water the way people on the West Coast might think about water, where they have very limited amounts, and so the conservation message is not as strong.
Thank you.
I'll be quick. With the Clean Water with the Clean Water Act, are you meeting all the mandates coming from Washington?
The Clean Water Act is on the sewer side, but the Safe Drinking Water Act, yes, we are meeting all those mandates, and it becomes more and more challenging as they continue to move the regulations down. The disinfection byproduct regulations are a challenge for us, and that was another reason that we had concerns about the Owenton treatment plant. Would we be able to continue to keep those levels low enough to meet that regulation? But in fact, we're actually exceeding the government regulations, and we're part of the American Water Works Association and EPA partnership for safe drinking water, and they set levels that are even more stringent than the actual regulations. And I'm happy to say that I have a couple of employees going to pick up our 15-year award. We've done that for 15 years at 2 of our treatment facilities, and so they're picking up that 15-year award next week for us.
Congratulations. Are you doing any public education to make your customers aware of the, I call it Clean Water Act, but it's the act cleaning up our water, so that they'll know about future costs and that sort of thing? And
I can't specifically say that we've educated them on the future costs, but we've educated them a lot on the requirements and the quality of their water compared to those regulations. And in our environmental stewardship, our source water protection efforts and things like that, we do a lot of environmental grants and really try to help people understand how important keeping those watersheds clean is to the safety of their drinking water.
thank you. any redirect?
I do have about, I'll be very short on redirect, maybe 5 or 10 minutes. Ms. Norton, I know you weren't at Kentucky American in the mid-2000s, but have you heard that at that time Kentucky American did not have a single tariff pricing structure?
Yes.
They had different tariffs for the Northern Division and the Central Division at that time, correct?
Yes.
And are you aware that before the acquisition of the Owenton system was completed, Kentucky American filed with this commission a request for approval of that transaction and also approval to charge to the Owenton customers the existing rates the Owenton customers were paying?
Yes.
And is it your understanding that in that case, the commission ruled on the approval of the acquisition? We don't need to rule on that because this is a municipal utility and the approval of that acquisition is not required.
That's correct.
But do you remember that the commission also said in that order, yes, you may charge Owenton's existing rates, but the commission also said the commission places Kentucky American on notice that Kentucky American's next application for a general rate adjustment should contain a proposal for a single rate schedule applicable to all Kentucky American customers. And this was in a 2005 case order, is that correct?
That's correct.
And in Kentucky American's next rate case, which would have been its 2007 rate case, did Kentucky American bring to this commission a proposal for a unified rate structure?
Yes, we did.
And was that rate case settled?
Yes.
Did the settlement of that rate case, which included the LFUCG, the Attorney General, and Community Action Council, include a recommendation to this commission to move to a single tariff pricing structure after the Owenton acquisition, of course?
Yes.
Was that settlement approved by this commission?
Yes, it was.
And so that unified tariff structure has been in place ever since, correct?
That's correct.
And you talked about some of the advantages of the unified tariff structure. And one of the things you said was that there's a cost sharing spread through all of our customers. Is that right?
Yes.
That's a two-way street, isn't it? And what I mean by that is when KRS-2 was built, which for now is solely devoted to the Central Division, the Northern Division customers in Owenton have been paying for that. Is that correct?
That's correct.
So in some sense, the Northern Division customers have been subsidizing the Central Division customers for the cost of KRS-2. Is that right?
Yes.
The two-way street back would be for the Fayette County customers to in some way help out the cost of the Northern Division connection. Is that correct?
Yes, and the Central Division customers will save on the operating costs once that treatment plant is decommissioned.
Okay. The next topic I had a little bit of redirect on would be the billing services termination, and I'm going to hand to you what I will call Kentucky American Exhibit Number 1. Now, Ms. Norton, I don't know if you've seen this exhibit before. I'll tell you what it is as denoted at the top there. This is a document that was provided in this case by the LFUCG as a response to a commission staff data request. If you want to take a minute to read that document, I have a couple questions for you about it, please.
I've read it.
Okay. The document that was produced by the LFUCG is a copy of an email from Cheryl Taylor to Bill O'Mara and Jane Driscoll. Would you agree with that?
Yes.
Who is Cheryl Taylor?
Cheryl Taylor was an employee when I first came. She was an employee of Kentucky American when I first came here, and then within 2 weeks after I got here, she left and went to LFUCG to work in their environmental quality department, I think.
Okay. And who are the recipients of the email? Do you know who William O'Mara is, and do you know who Jane Driscoll is?
Yes, they were people from the finance department that we were working with on the billing agreements.
At the LFUCG?
At LFUCG.
And Mr. O'Mara is, in fact, an LFUCG witness in this case. Is that correct?
Yes.
The subject of this email, and I'll paraphrase it, but is it reporting from Cheryl to Mr. O'Mara, from Mrs. Taylor to Mr. O'Mara and Ms. Driscoll, a lunch that you had and Susan Lancho of Kentucky American had with Ms. Taylor?
Yes.
is the date of this email July 1, 2011?
Yes, it is.
Is it your understanding from this email that Ms. Taylor was reporting to Mr. O'Mara and Ms. Driscoll that Kentucky American was going to terminate the billing contracts for the three different services the city provides?
Yes.
Is it and that the date of that email and therefore the date of that luncheon were at least 1 month before the August 1, 2011 David Baker email that was Commission Staff Exhibit number either 1 or 2 that Mr. Woocher introduced this morning?
Yes.
So at least as of July 1st, 2011, this was the latest date upon which some informal notification was provided to the LFUCG by you. Is that correct?
That's correct.
Of the termination of the billing services.
Yes.
Is in the second paragraph of that email, could you describe what that paragraph means, as your understanding and based on your memory of that lunch, in terms of the decrease in collection rates that was occurring on the collection of the city services bills?
Yes. Beginning early in 2011, we started to see the aged receivables increase on the LFUCG portion of the bill because people were choosing not to pay their landfill fee, which was $4.50, or their stormwater fee because they learned very quickly that we couldn't turn their water off if they didn't pay that portion of their bill, so they were not paying their full amount.
Okay, and prior to the Commission's order in the 2010 Kentucky American rate case, which came out in December, when Kentucky American received payments from its customers for city services, the payments were applied in a particular order. Is that correct?
They were prorated.
Okay. And
prior to that.
Okay, and then after the Commission's order, the Commission ordered Kentucky American, no, you must pay the sewer portion of the bill first when those payments come in. Is that correct?
Actually, the payments were applied to water first, and then sewer, and then the remainder of the bill.
Okay, and as a result of the Commission's December 2010 order, Kentucky American had to change the priority of the application of payments. Is that correct?
That's correct.
And as a result of that, the collection rate on the landfill and on the stormwater fees started to decrease. Is that correct?
Based on what we could tell, their collection rate in general, it's not tagged to a specific line item, but as that accounts receivable, the aged part got much larger very quickly.
So the collection rate was going down long before the exit from the billing contracts, which happened over a year later. Is that correct?
That's correct, yes.
Okay. Just a couple more minutes, Your Honor. On the issue of the low-income effort, and I know you weren't at all the meetings that have been discussed here today, but those meetings began with the first one, which I think the testimony was in February of 2011, shortly after the Commission's 2010 rate case decision. Is that correct?
Yes.
Is it, and you attended the first meeting, right?
I believe so, yes.
Is it your understanding that that all the parties were in a consensus throughout the first 3 quarters of 2011 that a legislative solution or a legislative approach would be good, and that the full support of all the parties, including the Attorney General, including CAC, and including LFUCG, was there for the introduction of that legislation in the 2012 General Assembly?
Yes, as I understood, real progress was being made at those meetings, and we were headed down a specific path.
As indicated by all of the lawyers for those entities exchanging emails offering red line comments to the legislation that had been drafted, correct?
Correct.
And is it your memory that it was the 4th quarter of 2011 before Kentucky American learned that the full support of all parties would not be there?
That's correct.
Is it your understanding that it was the Attorney General's office that decided it wouldn't fully support the legislation, at least in a vacuum?
Yes.
Kentucky American's obligation is to serve its entire customer base, a part of which is its low-income customers. Is that correct?
Yes.
Community Action Council's mission is a little bit different than Kentucky American's, is it not?
That's correct.
Its primary goal is to help out low-income customers however it can. Is that correct?
Yes.
Are you aware of any effort that Community Action Council made after the Attorney General advised the parties that it would not fully support the legislative solution in a vacuum. Aware of any efforts that the CAC made to try to convince the Attorney General to once again support the legislative solution?
Objection, Your Honor. Council's not providing any underlying basis for these assertions. Is there data on these assertions that the Attorney General made any withdrawal of its support for a legislative solution?
I'm asking what Cheryl Norton remembers that happened in the fourth quarter of 2011. She has answered that question based on the best of her memory. The question that has been objected to is whether Ms. Norton is aware of any Community Action Council efforts to go talk to the Attorney General's office and convince them otherwise. She either is aware of that or not. And I don't know what the answer is, but I'm sure she'll tell us.
If she knows.
I'm unaware of any attempts to do that.
No further questions.
Do have some recross.
Yes. Proceed.
Ms. Norton, regarding the affordability issue, on what evidence, I'll just ask the question, on what evidence do you rely for your statements today that the Attorney General would not support legislation relating to affordability?
As I recall, I saw an email towards the end of 2011 that that said that the Attorney General's office would not support the legislation.
Was that email related to the Attorney General's request for additional data from Kentucky American Water concerning some of the things that we talked about as part of the collaborative process, including the water manual that was exchanged, that information shared between the Attorney General's office and your office?
That was before we discussed the water manual, I know.
Would you be willing to produce that email?
Yes.
Okay. Did the Attorney General ever say, as we move toward more of the 2012 time period, 2012 into 2013, I believe you spoke and discussed this with staff exchanges of emails with respect to redlining, et cetera. Did the Attorney General ever say that it would oppose legislation proposed by either, or the legislative language, that draft language, proposed either by Kentucky American Water or by the Community Action Council in terms of those red lines?
I don't know if it was said that they would oppose it, but I do know that there was a very strong message that it would not be supported.
And that was the language that was used, that it was not be supported, to your recollection?
To my recollection, yes.
We'll see the email and we'll take that up.
For the record, it's an October email from Mr. Spinard that we'll produce after lunch.
Good.
You said correctly that you attended of several meetings during this period between 2011 and 2012. A handful of those, maybe 2, maybe 3. Is that correct?
That's correct.
Therefore, how do you know specifically the position of the Attorney General, Mr. Conway, with respect to this legislation?
I guess the only thing I know is the staff, the apparent position that the staff was taking based on the last meeting that I was at, as well as the email.
And that specific position was that it would not oppose the language proposed by either Kentucky American or by CAC, but it would not necessarily advocate, be lobbying, et cetera. Is that your understanding?
I don't think the word oppose was ever thrown out,
Okay.
but the feeling was that there might be no support would be seen as opposition.
And that's your opinion?
That's my opinion.
Turning back to testimony that you discussed today with CAC, on questions with CAC, you questioned the veracity of a opinion piece that came out with the Lexington Herald Leader. Is that correct?
Yes. I guess you're referring to the sales being incorrect. The sale
I'm referring to the editorial that appeared on May 23rd.
Yeah, and the fact that the sales to those two communities is not true.
The May 6th announcement by President and CEO Jeff Sturba.
Oh, yeah, like I said, I assume that that's right. I don't have those numbers in front of me.
Are you familiar with American Water Works issuing announcements, press releases, that
Yes.
sort of thing? And if there was a Business Wire report regarding Mr. Sturba's statements on May 6th itself, attributing it directly to Mr. Sturba, would you believe that that was accurate based on the statement that was issued on May 6th?
I would if they had that, if that was actually what was in that statement, yes, I would believe that.
Okay, so if it was quoted on May 6th as Business Wire, and I'm holding that in my hand, I'm going to read from it, and I'm happy to provide that, but I did not make copies, that he stated, on a compounded basis, comma, our annualized earnings have increased by 14% from 2010 to 2012.
Yes.
Subject to check.
Yes.
Would that be accurate?
Yes.
Okay, thank you. I just have a few more questions. Thank you all for bearing with me. You discussed at length anecdotal issues and concern regarding bill confusion with respect to the third-party billing. Will adding a DSIC and/or a purchase power and chemical expense rider add complexity as well to the billing process? And how with particularity with regard to how and when rates are going to be charged with respect to those additional trackers and surcharges?
Yeah, I think it will add a minimal amount of complexity, but whenever we put an increase or a surcharge on our bill, we communicate that very well with the customer through bill messages as well as bill inserts.
Mm-hmm.
Whereas when we're billing for other entities, those things don't have to happen. There was no requirement that a bill insert be done, so that the customers understood what those charges were for. And these charges will be related to their water service. So I think that knowing what they're paying for their water service, that's not going to be an issue.
Did Kentucky American Water, before cutting off those billing services, ever offer to Lexington the opportunity to put in billing inserts along with your billing inserts to explain that the difference and try to alleviate some of that concern and confusion?
We had done that ourselves. We had done bill inserts trying to explain their bill and the different parts of the bill. We still saw some confusion there, and I can't speak to the specifics of the situation, but I do know that there was one sewer increase where we were specifically asked not to notify customers, but I don't even know the timing of that. So, we took care of our own bill inserts and tried to explain the bill through that for our customers.
You've heretofore indicated your favoritism for the single tariff pricing. Would not instituting a DSIC impact the simplicity of this rate structure and require additional review by the Commission between rate cases?
I'm sorry, can you repeat that question?
Absolutely. With regard to instituting a DSIC, won't that impact the simplicity of the current rate structure and require additional review by the Commission between rate cases?
I don't believe that will impact the rate structure. It's the same kinds of things that we would bring forth in a full-blown rate case. But if it can help extend the time between rate cases, I think that's a savings to our customers. And the Commission still reviews all of the investments made. It's just a much more streamlined process than going through a full-blown rate case.
There will be additional reviews under your proposal in between rate cases.
An annual review, correct.
And the Commission and Commission staff will have to conduct those rate reviews.
Yes, but it's much streamlined, and it's a protection for the customers.
We do have some additional questions regarding the confidential record, Your Honor, but I defer to you all as to whether you want to take that up now. It's really only three questions.
Your Honor,
I'm sorry.
I just have one
I had
or
a
two
couple
questions.
also. Just a
Okay.
couple.
Understood.
We're I'm going to go on, but I'll call a halt to this for the sake of everybody's growling stomachs. We'll at 1:30. You want to go into those now?
Well, I've got the confidential, so
Okay.
if they've got non-confidential questions, we can defer to them.
Let's get more.
Thank you. Ms. Norton, in response to Mr. Ingram's redirect question just now, you answered, you stated that, or you agreed that CAC's mission is to serve its low-income base, and your company's, mission is to serve all its customers. But now, when you agree that having 17.5% of your customer base at the poverty level is a fairly significant amount of your customers,
I definitely think it's a significant amount of customers. I think it's a huge community issue that needs to be addressed from a community perspective.
That, you know, that we're talking here about the most basic resource, and that is water in their homes to use.
Yes.
When you stated that you weren't aware of any action CAC made to try to convince the Attorney General to support the legislation, is there a time period that you're referring to, particularly when Mr. Ingram asked you that question? He said he just wanted to know if you were aware of any action CAC made, and you said you were not aware. What time period are we talking about here?
I assumed he meant from the time that we first realized that there wasn't full support until we had our last meeting.
Was this after this new rate case was filed? After the last meeting, the December meeting of 2012?
No, that was before this rate case was filed.
Did you talk to Mr. Birch about whether he had talked to the Attorney General? Do you have any basis for this other than just you don't know?
No, he asked me the question, was I aware of any attempts? And
You're just not aware,
I just
because
don't have
you
any
really haven't
attempts.
talked to anybody about it, correct?
I actually called CAC and talked to Charlie Lanter a while back and asked if CAC wanted to move forward with this without the support of the Attorney General. And he said he would talk with Jack and get back with me, and I never heard anything back. So I assumed that to be a no at that point.
I had a couple questions. Is it your belief that the cost of providing the services exceeded the money you were getting from the Urban County government every year for providing the billing?
I do not believe that to be the case, but I can't prove that.
What's the status of the BT business? Is it business transformation, whatever that stands for? What is the status of that right now?
The status is that we had two different releases that were going forward. The first release included our financial and HR parts of the business. That all went live, all of our purchasing, that all went live back in August, like on August 1st of last year, of 2012. And so then the next step in the process was to go live with our customer information systems and our work management systems. And we are part of the states. There's a number of states that were going live in May and a number of states that were going live in October. We were in the group that went live on May 20th. And we've been live since May 20th, and have
Is it
had
so far so
few-
good on the go live?
Yeah,
All right.
so definitely so far so good. Lots of preparation, and it appears it's paid off.
Do you? I mean, from your viewpoint, do you think what is the time period you know whether that has succeeded or not on going live? Have you exceeded that already, and you know that it's going to work out?
It's gone much better than it could have so far. We're not fully. I'd say that we're not fully as efficient as we're going to be going forward. It could take, we've heard, as much as 3 years before we can really fully say that we're as efficient as we could be with that system, but things are going well.
I believe you testified earlier that as an example on how this unified billing might work on spreading the cost, so to speak, that oftentimes it would be around a penny or less a month on someone's bill. I apologize for not having this, but I believe somewhere in you all's filing you have the actual cost breakout for the Owenton system as part of this case. Do you recall what that amount is per month?
Are you talking about the purchase of the Owenton system or
I'm
the
sorry,
pipeline?
I'm
Are you talking about
the
the pipeline? Yeah, I think it's somewhere less than 30 cents per month on
And
a
is that
customer's
the
bill.
entire cost, or is there, in the future rate case, will there be another part of the cost?
I'm not sure. You'll have to
Is
ask
Ms. Bridwell my person on that? Do you think?
Ms. Bridwell or Ms. Forzel.
Would you agree with me that the proportional benefit is not necessarily the same depending on where your customers may reside within your system?
That's possible.
Can you provide, as part of a supplemental data response, any data you all have in support of the collection rate going down prior to the billing transfer in September of 2012? And hopefully this is my final question. Would you have considered eliminating the billing for the urban county government, even if the BT process was never contemplated by the company?
Yes.
I don't have any other questions.
Go on the confidential record.
Next,
If
I
that's
have a
okay.
couple before we get. I just want to follow that up. As president of Kentucky American, you report to whom?
Nick Rowe.
And does he report to the executive leadership group?
He reports to Walter Lynch, who is on the executive leadership team.
Okay, and so information that flows, let's say a policy is developed by the executive leadership group, it may flow down to the division, I guess he's a division leader, is that?
Yes.
And it flows down to him, and then he sends it out to those that report to him? Is that
That's
generally how
one
it
method,
works?
yes. Mhm.
I mean, if there's some policy that's going, he's not going to hold it close to his vest, but he's going to let the people that work for him know what's going on.
Yes.
Okay. You heard Mr. Baker testify earlier today that the executive leadership group had made the decision early in 2011 to move away from third-party billing. Were you aware that they had made that decision?
I was aware that there were discussions in Kentucky when I came here in early 2011. I wasn't aware that the executive leadership team had made that decision or that they were having those discussions.
And you were here when Mr. Baker testified that the division leaders at
Yes.
least had been informed of that.
Mhm.
Okay. One other question, and that regard is the consortium was supposed to be reporting to the commission, and it did file reports. Is there any reason why, when it filed a 6-month report, which was supposed to be, I guess, the last report or the report before the general session in 2012, why the draft legislation wasn't at least provided as something that was being considered, given the fact that the commission had already noted that it was looking at legislative at the problem as a potential legislative one that would require legislation?
I can't answer that question, I'm sorry. I don't know why it wasn't submitted as part of that report.
Okay, thank you.
Two real quick things. Yes, Ms. Norton, two real quick questions. The first is with respect to usage as well as the effect of the number of defaults. Is Ms. Bridwell the person I should ask about both of those subjects?
Usage, yes, definitely. The number of defaults, I guess it depends on the question that you have.
Who are the options to ask that of?
Melissa Schwarzel pulled the numbers together on the defaults.
Okay. And then finally, on a bunch of the hearing this morning has been on the inability of the group, the collaborative, if you will, to go forward. Do you think it's dead? I mean, if the commission, is this something that the commission should say, take another look at it? Or, what's your observation?
I'm not really sure, to be honest. I still strongly believe that legislatively we need to do something before we can move forward with a rate structure or some kind of a change to the way the rates are charged. And if we can't get the kind of support that we need so that the elected officials will support it, then I don't know if we can make it happen. We're willing to take it forward, and our lobbyist is willing to identify somebody to try to help us take that forward. But I think it has to be a group effort in order for it to be successful.
Thank you.
Chairman, in light of the fact that the questions that we have relate to the confidential record, do you want to take a break now, since we'll have to clear the room of anyone who hasn't signed off on that, or wait? I defer to the commission and commission staff as to the preference.
We will come back early from lunch, and we'll have only those people in that have been cleared. Trustee Ewell will supervise that. And then once that's complete, we'll have everybody come back in. And so we're now at 1:30, and about 2:30,
Okay. Thank you.
To adjourn. Anything else on redirect?
No, no, sir, not from you.
I have nothing for the witness, Your Honor.
No redirect for Ms. Norton, Your Honor.
Question? Thank you, Ms. Norton. You're excused. Next witness.
Yes, Your Honor. Our next witness is Mr. Keith Cartier.
You sworn? Solemnly swear to tell the truth, the whole truth, and nothing but the truth, subject to the rules of perjury. Have a seat. Speak loud and clear. Your name, what you do, and why you're here.
Keith Cartier, Vice President of Operations for Kentucky American Water. And here to answer questions.
Mr. Cartier, did you prepare and cause to be filed direct written testimony in connection with Kentucky American's December 28, 2012 application in this case?
Yes, I did.
If I were to ask you here today the same questions that were asked in that written direct testimony, would you provide the same answers?
Yes, I would.
The witness is available for cross, Your Honor.
General.
Yes, Mr. Cartier. Your experience with American Water, the American Water family of companies dates back to 2003, is that correct?
That is correct.
Okay. And does that experience include serving with Pennsylvania American Water, is that correct?
Yes.
Now, Pennsylvania is one of the states that Kentucky American cites as having a distribution system and infrastructure or improvement charge, or DSIC, is that correct?
Yes, it is.
Okay. And is it true that Pennsylvania's DSIC is the result of a legislative enactment that occurred in 1996?
I could not answer that. I do not know the answer to that.
Okay. Are you aware whether it is a legislative or statutory?
I'm sorry, I am not.
That's. Do you recall approximately when DSIC went into effect in Pennsylvania?
I do not know when. I know when I began in 2003, it was in effect in the area in which I worked.
Okay. And is it true that the DSIC surcharges for water utilities, give me 1 second, hold on 1 second. Are you aware whether Pennsylvania recently enacted legislation permitting utilities to utilize a forward-looking test period?
I'm sorry, I do not know.
Give me just one moment. Now, it is true in this proceeding that Kentucky American is using a forward-looking test period. Is that correct?
Yes, it is.
And during the forward-looking test year, will the current Owenton facility plant be in service and required to operate for a period of approximately 4 months beyond what the company originally detailed in its application?
I can't recall when that change went into effect, if it was at the initial application or afterwards, but the beginning of construction occurred later than first anticipated. So there was a time where planning or budgeting might have had the plant and the folks' expenses associated with that plant out of the initial budget, and the rate case may have occurred at a later time. So I believe Ms. Schwarzel may be able to answer those specific questions on cost.
I'm sorry, say that witness's name again?
Melissa Schwarzel.
Melissa, okay. Do you recall Mr. Keithley also making some adjustments in his testimony regarding the Owenton facility?
I couldn't tell you specifically what adjustments he may have made regarding that.
Okay. That's all we have at this time, Your Honor.
I have no questions.
Questions?
I have just a few. Mr. Carrier, good afternoon.
Good afternoon.
You provided some information regarding the, in response to a commission staff request, you indicated that the company assumed in determining the construction replacement cost for Maine and making its calculation on the effects of the disc, that the cost would be $190 per linear foot. Do you recall that?
May I have that number, Mr.
Yes,
Wilson?
sir. It's the $190 estimate was in response to commission staff's second request for information, item 50.
Okay, I have that.
You have that? Okay. And in that one, and I apologize, I'm trying to switch between computer screens, and it's not as good as I wish I was. Now, in response to a request, you had given us the $190 foot. Then, in response to commission staff's third information request, item 20, you gave us a breakdown in terms of the cost, how you derive that $190 per linear foot estimate. Do you have that?
Yes, I do.
Okay. In examining that, we were trying to, commission staff was trying to ascertain whether that figure is consistent with what we've seen in the cost per foot in other cases that had been before the commission. And in several cases, we've seen a much lower figure, coming anywhere from $31 per foot to $67 per foot. And so we're trying to understand why that dollar amount would be so much greater than it would be in other water utility cases.
Now, Ms. Beardwell may be able to answer more specifically, but my experience has been, depending on projects, you do get a wide range of bid costs, depending on where the project is, timing associated with projects, and that sort of thing. So the costs, the average costs that are shown here for the 2012 replacement projects are, you see $187 there, or for those projects that were actually experienced there for the 2012 projects. You know, if you're working in a place that doesn't require a lot of pavement, a lot of street repavement, may not be in rock, there are different components that affect that. And the pricing that we get for main replacements kind of is reflective of what's anticipated in construction.
Let me just follow up with, would, in comparing these prices to other utilities, would the urban nature of some of these projects lead to a more or a higher cost per foot than if it were done in a, let's say, a suburban or rural setting?
Generally, that would be the case.
And just for the projects, I think on the company's response, your response to the third staff information request, number 20, you give a listing of those projects. And just for the record, can you identify, are most of these projects in an area that would be considered extremely urban, in a downtown area, or?
Yes, some of them are. Florida Street, Transylvania Park. You can see the the Transylvania Park is an example, the second grouping of projects together, that's where that kind of higher price came in. The relocation US 25 is a little bit lower priced, and that is not as much in an urban area.
You know, you have some projects that appear to be almost $1,200 dollars per foot. Again, why would those prices be so high?
I'm not sure I see that one, Mr. Witcher.
It looks like if you go down on the table, close to the end, the second grouping from the end, I think one of the South Limestone
South
replacement.
Limestone. Well, I couldn't answer that specific question, but certainly on a unit price basis, when you only have 9 feet, I'm not sure what was involved. If that might have been a valve, it might have been something like that, where on a cost per foot basis, it just looks extraordinary.
Okay, that's all we have. Thank you. Well, I'm sorry. I do have. You had responded to some questions regarding some of the billing contracts. Would you be the appropriate person to direct some questions to?
It probably depends on the questions, but I can.
Well, there are very few, but let's take a stab at it. In terms of the cost or the price range in those billing services contracts, are you aware of any cost of service study or cost allocation regarding the actual activities involved in providing the service?
I am not. I am not aware of kind of a cost of service type study.
Do you know of, and now you've been at Kentucky American for how long?
5 years, 5+ years.
Are you aware if any study had been performed prior to your arrival at the commission since, let's say, 1995 or around that time frame when the company began providing billing services for Lexington Fayette Urban County government?
I am not aware of any that were conducted.
Do you? One final question. At any time, how long have you been responsible for managing the billing services contracts?
That was under my area of operation for the whatever 3+ years or 4 years that we had it when I was here. Yes.
During the time that you were responsible for the management of those contracts, was the question ever raised regarding doing some type of allocation study or whether a statute required a specific allocation to ensure that the costs attributed were properly attributed to the billing services as opposed to the water utility customers?
Not a specific type of cost of service study. I'm not aware of any that were done like that, and I'm not aware of statutes that may require that.
That's all we have. Thank you, sir.
Questions?
Good afternoon, Mr. Cartier.
Good afternoon, Chairman.
In the application, it says, and I'll just read the first sentence in paragraph 3, to meet continuing demand for adequate service, Kentucky American Water has continued to invest substantial capital to maintain and upgrade its facilities, including main replacements, treatment plant upgrades, and energy efficiency projects. Tell me what kinds of energy efficiency projects you all have invested in.
Well, there's a couple that have been completed and a couple are still ongoing.
Okay.
The lighting kind of retrofits, energy audits were 2 of those types of investments. There's
lighting and what?
2 different lighting type studies. The larger energy efficiency projects deal with pumps and motors at the treatment facilities and pump stations. And when you look at our energy consumption, the biggest part of it has to do with that energy that's used in the production and movement of water. So the couple of projects out at Jacobson Reservoir, as an example, replacing series of motors and pumps there. at Richmond Road Station, replacing one of the high service pumps there. And as we go forward, looking at where does it make sense to invest to replace pumps and motors to get a higher degree of efficiency out of that combination.
The Richmond Road and Jacobson Park, does that include the pumps that are used to pump water up from the Kentucky River? Is that
No.
separate?
Well, I should have answered that quickly. For Richmond Road Station, we can pump water either directly out of the reservoir, or we can pump it from the river over to Richmond Road, or from the river to the reservoir. The Jacobson Reservoir project is dealing with those pumps that would be used to take water out of the reservoir and over to Richmond Road Station.
So the Richmond Road pumps are the ones that pump water from the Kentucky River?
No, the Richmond Road Station pumps are the ones that, after the water was treated, would pump the water out into the distribution system.
Okay.
So that was the Richmond Road would have been one of those high service pumps. And typically we refer to high service pumps as kind of finished water. Low service pumps are typically referred to as those intake pumps that might pump out of the reservoir or out of the river.
And are there plans to look at, or have you already looked at the pumps at the Kentucky River and at, in the Lexington area, as well as the newer pumps at KRS-2?
Yes, as part of our comprehensive planning study, there will be kind of a suggested approach of here's what you should be looking at in sequence. So it's kind of more of an engineering study approach. That as you look at pump replacements and investing, here's the ones you should focus on. And we looked at things where pumps might not be operating as efficiently as they could. So they might be off their curve. Their pumps operate on can pump low, you can turn them up and pump high. And along that curve, you have different levels of efficiency. So it's matching the pumps and motors with the kind of the current and projected operation is what you're looking to do to get the most out of that combination of pump and motor.
When what your response implied to me that that you're going to be doing this in the future, looking at this, so that you don't have that plan in place yet?
No, it's not finalized. The comprehensive planning study will be finalized, my understanding is this year. But we're kind of not waiting for the plan. The couple that we already undertook were high on that list. And they're also, in some respects, motors for which, or pumps for which we might have been having problems with. So the high service motor at Richmond Road, as an example, was one we weren't necessarily having that much problems with it, but it was time to replace it.
And maybe I missed this. Who's doing the comprehensive planning study?
It's out of the engineering department, so it would be in conjunction.
Locally?
It's local operations in conjunction with support, and I would say the authorship would come from the American Water Services Company Corporate Engineering Group.
Thank you.
Redirect?
No, Your Honor.
Thank you, Ms. Cartier. You're excused.
I think Ms. Hahn had something.
Sorry.
I just had one brief question, Mr. Cartier, and I apologize, but the question regarding leaks reminded me. Give me just 1 second. In your testimony on direct, you gave some numbers. I believe it was 13% with regard to your water loss percentage for 2012. What is Kentucky American's percentage of water loss due solely to line breaks and leaks? Would it be less than that 13%, subject to check?
Is there a reference number of that?
Yes, on your testimony, it would be on direct. Let me find it. And I apologize. Just wanted to get that into the record. I believe it's page 7, line 10, is where you reported a water loss percentage. But then over on page 8, you discuss, or maybe actually it's page 9, you discuss more of the leak aspect. And I was wondering if there's a difference between the water loss reported at 13% and water loss attributed solely to leaks.
There is. It's relatively minor. On the PSC reports, the water loss percentage is a calculated number. And embedded in that number is breaks, line leaks, and anything else that you can't account for, that you don't know. So the line leakage is the largest component of that, but it's not the only component of that.
Thank you, that's all, Don. I appreciate it. Thank you, Mr. Carter.
Any other questions? Seeing none, you're excused.
Thank you.
Thank you. Your next witness?
Our next witness is the last telephonic witness for Kentucky American. It's Mr. Paul Herbert. We'll try to get him on the line now. Please.
Thanks for calling Gannon Fleming. If you know the number of the person you are calling, please dial it now, followed by the pound sign. Please hold for
Paul Herbert. Herbert speaking.
Mr. Herbert, this is Monica Braun. You were live at the Public Service Commission.
Okay.
Mr. Herbert, will you be sworn?
All right.
Solemnly swear to tell the truth, the whole truth, and nothing but the truth, subject to the rules of perjury?
I do.
Your witness?
Mr. Herbert, this is Monica Braun. Did you cause to be prepared direct and rebuttal testimony as part of this proceeding?
Yes, I did.
And if I were to ask you those same questions here today, would your answers be the same?
Yes, they would.
The witness is available for cross.
I think I'm the only one. So.
Yes.
Good afternoon, Mr. Herbert. My name is Iris Skidmore, and I represent the Community Action Council for Lexington, Fayette, Bourbon, Harrison, and Nicholas counties. And where are you calling in from, or where did we reach you today?
I'm in Harrisburg, Pennsylvania.
Well, I'm going to ask you some questions, and if you can't hear me, please tell me, and I will try to speak up. But I'm fairly close to the phone, so hopefully you can hear me. In your rebuttal testimony that you filed, do you have that with you?
Yes, I do.
On page 3 of that, you discuss Mr. Birch's proposal for an increasing tier block structure. And in the question on line 9, you were asked to address Mr. Birch's testimony with regard to rate design, and you stated Mr. Birch is concerned about the effect of the rate increase on low-income customers. Now, how was Kentucky American, was Kentucky American concerned also about the rate increase on low-income customers as you prepared this rate design?
I believe, yes, the company is concerned.
What kind of analysis did you prepare that would have determined the effect of this rate increase and the rate design that you're sponsoring, how it would have affected low-income customers?
Well, we would have done a bill comparison of the effect of the increase, various levels of usage.
That's what you did?
Yes.
Do you know what percent of your customers are low income? Or at least living in poverty at 100% of the poverty level?
Only from testimony that I heard earlier today that it was, I believe, was mentioned 17.5%, but I haven't independently confirmed that.
You have no reason to doubt the truth of that, do you?
No, I do not.
Do you recall the order from the last rate case in 2010? In the case number was 2010-00036. Were you involved in that?
I was involved with that case, yes.
Would you have a copy of that order with you where you are?
I don't believe I do.
Well, I would refer to page 75 of that order, and the commission, I'll read you this, and if you get lost in a lengthy paragraph, tell me and I'll start again. We find insufficient evidence in the record to support CAC's rate design proposal or to clearly demonstrate the implementation of such proposal will benefit low-income customers or create appropriate pricing signals. Accordingly, we have not incorporated CAC's rate design proposal into Kentucky American's rates. We find, however, that CAC's proposal should be further studied and additional customer data gathered to permit a thorough assessment of the proposal's potential effects. And then it goes on to set up a collaborative effort as well. Now, did you get any customer data provided you that would have permitted this kind of thorough study?
No, I did not. My understanding was that there was what would be required would be legislation in order to permit such a study, or at least legislation to allow for such low-income rate design.
Are you saying you thought there would have to be legislation in order to have a rate design that was based on an inclining block? Because that's what I'm asking here. Was there any data provided to you to look at that question?
No, there wasn't.
One of the reasons that you gave for your conclusion that Mr. Birch's solution is not the most equitable is that you said that all customers would get the same break, even those that cannot afford the full rate, correct?
What I was indicating was that in a tiered structure that Mr. Birch supported, it would give a break to all customers, even though a lot of those customers could afford the full rate.
Wouldn't an increasing tiered block structure also promote water conservation?
Well, an increasing tiered block structure is more of a conservation rate oriented structure as opposed to a low income structure.
Isn't it true that in Lexington, the government's spending millions of dollars to improve its sanitary sewer system? Are you aware of that?
I do not know.
So you don't know how water conservation would affect that effort?
I'm sorry, I didn't hear that.
So you don't know how water conservation or conserving water in Lexington, using less water would affect the sanitary sewer system?
Well, less water entering the sewer system would reduce the flow to the wastewater treatment plant. I would imagine.
You also stated on page 3 to 4 of your rebuttal testimony that Mr. Birch's increasing tier block structure proposal places an increased burden on customers that cannot conserve, or customers with home gardens, or large families who may also be low income. Do you know what the average low income family is?
In what respect?
The size of the average low income family?
No, I did not.
If you don't know, would you be surprised to hear it's probably 4, just like the non-low income family?
I don't know that. I know that there are low income families that tend to have larger amount of children in the household, or multiple families sharing the same dwelling.
Mr. Herbert, going back to your comment about this wouldn't be fair to customers with home gardens or persons who cannot conserve, do you actually think that it's more important to burden low-income customers than customers with home gardens?
Well, I don't think they're mutually exclusive. I think maybe low income families may be using home gardens in certain efforts to reduce their food bill.
If you're a customer on a fixed income, say Social Security, and you're constantly faced with the choices of how that money's spent, food, medicine, electricity, please explain how your rate design allows that person to control her costs.
The rate design that was proposed in this case?
Yes.
Well, we didn't differentiate between low income and regular income. Fine. My suggestion as to how to address the low income situation would be a discount to the customer charge, which would be a benefit to those customers and would be measurable. That is the rate structure that Pennsylvania American uses and has been successful for many years.
And that's the approach that you stated in your testimony, correct? That there should be a discount?
Yes.
And are you aware this would require legislation? I guess you are aware of that if you've been listening today to the
I believe it would.
You also state that any lost revenue would then have to be recovered from other residential customers by slightly higher rates. Is that correct? That's what you said in your testimony? So you're proposing that cost be shifted to other customers, right?
That would be my recommendation.
Do you have any reason to think this type of legislation would be popular in Kentucky?
I have no idea.
Assuming that, well, you don't have any idea about whether this legislation would have a chance of being passed, then, correct?
I do not know.
But assuming this kind of legislation would not be popular, do you have a plan B for protecting low-income customers and helping them pay their water bill?
Well, I don't understand why it wouldn't be acceptable, but no, I don't have a plan B.
I think that's all I have. And thank you so much for appearing. I know this is awkward, but I appreciate your time.
Well,
Any other questions?
I have a few, Your Honor.
Mr. Richard?
Good afternoon, Mr. Herbert.
Good afternoon.
Can you hear me all right?
Yes.
Okay. I have just a few questions. Let me begin. The application that Kentucky American made provides for a public fire hydrant, an increase in public fire hydrant revenues of $659,367. An approximate 19.71% increase over current revenues. Was there any change in the methodology that you used in your current cost of service study from the methodology you used in previous cost of service studies that would have impacted this particular customer classification?
The methodology we used between this case and the prior case was the same.
Okay. According to the application, the percentage increase for private fire hydrants was approximately 10%. It was 19.71% for public fire hydrants. Would you have any explanation as to why the increase affected public fire hydrants to a greater degree than private fire hydrants?
Well, let me first correct your question that it's not only private fire hydrants, it's also most of the class are private fire lines into certain commercial and industrial establishments. The private fire hydrants only make up a small portion of that class. So overall, the private fire service classification required a 10% increase, of which the hydrants are only a small part.
Okay, thank you. I have some questions about third-party billing services and how those costs would be allocated, just on a theoretical point. If you were looking at a utility that provided water service but also provided as an ancillary service third-party billing, how would you go about allocating the cost?
I would, as part of our cost allocation, would determine what the overall cost to issue a bill, including the meter reading, and use that as a method to share costs between water customers and sewer customers.
Do you know if that was ever done by Kentucky American when it was performing third-party billing services for Lexington, Fayette, Urban County government?
I do not know.
In the cost of service studies that you prepared previously, where Kentucky American had revenue from Lexington, Fayette, Urban County government because of its billing services, how did your cost of service study deal with that?
It would have deducted the revenues received for that service and deducted it from the cost of service from all classes and all functions.
So there was never
on the functional side, it would have deducted it from the cost of the billing.
Are you aware of you've performed numerous cost of service studies for various utilities, is that correct?
Yes.
Have you performed cost of service studies for other utilities that provide third-party billing services?
Yes.
Those utilities, do they use the same methodology that Kentucky American had used in terms of the revenues that it received from Lexington Fayette Urban County government?
I really don't know. I don't get involved with that part of their business. I've done numerous studies for other American companies, but when it comes to actually determining what to charge the sewer utility, I don't get involved with that.
Okay. Let me switch gears here. Are you familiar with an issue that's been raised regarding how the cost of the Northern Division connection project, those costs should be recovered?
I believe those costs are being recovered over all service areas in a single tariff method.
Okay. There had been a question raised as to whether a surcharge assessed on the Northern Division customers would be more appropriate for the cost recovery, the cost associated with that project. Would you have an opinion on that?
I'm a full believer of single tariff pricing and believe that I've seen that work in other states, including Pennsylvania, New Jersey, and others, Illinois. And I believe the single tariff pricing concept is the best way to go in this situation with different service areas being served by a common utility.
Bearing that in mind, let me ask you to assume for the moment that the Public Service Commission decided to use a surcharge in lieu of having those costs recovered through the rates assessed to both the Northern and Central Division. How what changes would have to be made to the cost of service or the rate design that you've currently proposed in order to allow for that to be done?
Well, I hesitate to answer because I have not studied that. I'd have to analyze the costs that are separate or incremental to the costs for the general service area, and I have not done that. I just don't know how to answer your question.
Okay, thank you, sir. Just one moment. Just a couple more questions. As it currently exists, the Northern Division is separated from the Central Division. They're not connected. Is that correct? Is that your understanding?
I believe so. I'm not 100% sure, but I believe so.
Okay, and you spoke in support of a unified rate structure. Would the effect, or in your mind, what would the effect be once the completion of the Northern Connection project occurs, where the utility, where both divisions are receiving their source of water from at least one similar or one same plant? Would that strengthen the argument for a single unified rate, or what effect would it have on it?
I don't view the separation of systems to be a problem with single tariff pricing. believe that the fact that they are connected does make it more easier to makes it more easier to explain and support. But for me, that's not a requirement.
That's all we have. Thank you, sir.
You're welcome.
Sure.
Thank you. Mr. Herbert, this is Jim Gardner, and I'm a commissioner. How are you this afternoon?
Fine, thank you.
Let me ask you a question. Were the instructions that you received for your cost of service study and/or your methodology any different between this one and the one you did in the prior case for Kentucky American Water?
No, the methodology was the same.
Okay. Were the instructions any different?
I don't believe so, no.
Okay. On page 9 of your direct testimony in answer to question number 22, you received guidelines from company management, and number 2 said increase customer charges to recover a greater percentage of customer costs. My first question is, who did you discuss rate design guidelines at the company with?
Primarily Linda Bridwell.
Okay. And did she give you an explanation as to why she wanted to increase customer charges?
Well, that's typically a goal for most rate cases. The company needs to recover more of its fixed cost in the customer charge, and so this was no different than the desire to increase those customer charges, just like in any other case.
Did you recall that she gave you any specific reason why?
Not anything specific other than that the overall, I'm very familiar with the American water system, and I've testified on rate design in a number of states where American serves, and it's generally the Americans' desire to increase those fixed charges to, especially in light of declining consumptions.
Do you did she specifically state that to you, or are these really the assumptions that you've used in other cases as well?
It's both. It's my overall understanding of the American procedures for rate design, and supported by Ms. Bridwell in our conversations.
Okay, and so you're saying that in the prior cases you would have had this same instruction?
Yes.
Okay. Do you recall what the customer charge was before the last rate case?
I can get that for you, I believe. It was $8.60 for a 5/8 inch meter per month.
That's what it was before the last rate case?
That was what the present rate was in the last rate case.
Sure. Do you know what it was prior to the $8.60?
I do not know.
Okay.
I don't have that in front of me.
Is it possible that you recommended that it was $8.90 and not $8.60? Right now, that's what's in effect now is $8.
It's now $8.90. Yes. In the last case, we proposed $9.15, and as a result of, I believe, a settlement in that case, the rate became $8.90.
Okay, do you know why it would have gone up, the customer charges would have gone up, or your recommended customer charges would have gone up over $5 from $9.15 to $14.48? I mean, that's a pretty big increase, and can you tell me what differences you saw as to why there was such a big increase in a little over 2 years?
Yes, the company made some significant investments in the meter account. I believe it had to do with the AMR devices that were installed.
Okay. That's all I have. Thank you, Mr. Herbert.
You're welcome.
Mr. Herbert, this is Commissioner Breathitt. How are you?
Fine, thank you.
Do you know why the demand for private fire units increased by a factor of 1.5 over public fire units in your fire protection costs? I'm on page 6 of your direct testimony.
Okay. That's a factor that's been used for cost of service studies for Kentucky for many years, even before I became involved. And I believe there was a commission ruling that factor of 1.5 was to be used back in that time frame, and I just continued to use that factor.
And in terms of, I mean, I read your testimony on fire protection costs on page 5 and 6, but can you help me understand what elements went into the 20%, almost 20% increase in the public fire hydrants cost as opposed to the private?
I would actually have to go line by line through my study to see the difference between the allocated costs in the prior case to the allocated cost in this case. I have not done so. I do know if there's been any substantial investment into in the distribution system that would affect public fire costs, because they do share in a lot of those distribution system costs. I don't know if there's any if there's been any significant direct investment into the hydrants or maintenance of the hydrants themselves. I have not done that comparison, but that is something I could do.
Let me just ask staff, is that something you think we need, or do you have enough information?
I'm sorry, was that a question for me?
No, I'm having a colloquy with the staff.
Oh, I'm sorry.
I believe we have sufficient information.
Okay. It's not necessary. We have sufficient information.
Okay.
Let me see if I have anything else. I think that's it. Thank you, Mr. Herbert.
Hey, you're welcome.
Redirect? Anything else? Thank you, Mr. Herbert. You're excused.
I'm sorry I didn't hear.
Thank you for your testimony. You're excused.
Thank you. Thank you very much.
Could I see counsel here? Presume Brady Wells, you're next.
No, sir.
Okay.
Scott Rundgren is our next witness. There's some question about whether there are any questions for him, but certainly you're available if there are.
I have been, I was going to attend the Pilsen Society tonight, and now I'm introducing the guest speaker. So,
You need to be it.
It's Rick Atkinson. So he wrote a very hot book, and the press are doing interviews with him now. I probably need to leave a little after 4.
Okay.
I will start at 9 o'clock sharp. Does that stop any of your witnesses anyway? Or?
It causes no heartburn, Mr. Chairman. Obviously, this is a decision commissioners need to make. Is that there have been occasions where 2 commissioners have continued to hearing, but obviously without the completely view.
This is a very important case. It takes 3.
Understood, sir. I wasn't trying to suggest that.
Okay?
Okay.
Your next witness.
Okay.
Can I ask a question?
Sure.
Before you all leave.
I'm sorry. Wait.
The-
Come back. Mr. Witcher?
The,
He had a question.
Cheryl referred questions regarding a couple of the confidential exhibits to Mr. Rundgren. Is he your next witness?
He is.
Okay, so I guess it's possible that that there may be some questions related to that in confidential session. So
Okay.
I just wanted to communicate that in
Okay.
advance.
If it makes any difference, if we can avoid clearing the room, there is another data response that is not confidential that sets forth the Kentucky American authorized and allowed ROEs. If that's the nature of your questions, I can point that to you. If that will avoid us clearing the room, that'll be fine. If not, then we'll clear the room, obviously.
The questions have to do with, which was first? This was, the questions have to do with the line on total water sales, and I don't know if actually that's somebody else rather than him.
Total water sales really isn't Mr. Rundgren. It's probably going to be Melissa. They can probably answer total water sales.
Okay.
Mr. Cartier, if you need to call him back, you can, but Scott's probably not.
Okay.
The guy for that.
All right,
Okay.
so I wanted to sort of tell you what I might be asking before we clear the room. The next question has to do with the answer.
And if you're asking just about total water sales, just the numbers, I'm fine not clearing the room for that.
Okay.
If
I'll wait if he's not the best person.
Okay.
The other one has to do with future pipeline deals.
Okay.
And I don't know if you want the room cleared for that, and if he's the best person for that or not. Should that have been Cheryl?
I tell you what we'll do is we will make sure there's a witness still left in the lineup that can answer questions about that.
Okay.
Okay. Fair.
Thank you. So I won't be asking any confidential of Mr. Rundgren then.
Your next witness?
Our next witness is Scott Rundgren.
Sworn? Solemnly swear to tell the truth, the whole truth, nothing but the truth, subject to the rules of perjury.
I do.
Have a seat, speak loud and clear. Your name, what you do, and why you're here.
My name is Scott Rundgren. I'm a financial analyst in the race department for American Water Service Company in St. Louis, Missouri. I'm here to answer questions about my testimony.
Welcome.
Mr. Rundgren, did you cause to be prepared direct and rebuttal testimony in this proceeding?
I did.
And if I were to ask you those same questions, would your answers be the same today as they were in that testimony?
Yes, I would.
Witnesses available for cross?
No questions by the Attorney General?
None.
Just a
Richard?
couple. Good afternoon, Mr. Underwood.
Good afternoon.
Is it correct that on May 24th, Standard & Poor's reported that American Water Capital Corporation's corporate credit rating, that it upgraded American Water Capital Corporation's credit rating from BBB plus to A minus?
That date sounds correct. Actually, the upgrade affected the parent company as a whole, as well as Cap Corp, the American Water Capital Corp.
What effect would the upgrade in the corporate debt rating have on Kentucky American's forecasted long-term and short-term debt rates?
Well, it happened so recently that, we really haven't had a lot of time to, assess that going forward. In general, you would expect that an upgrade would tend to make debt costs to Cap Corp lower than they would have been otherwise.
When you said you haven't had enough time to assess, how long does it normally take to make the assessment?
Well,
And I'm asking, let me tell you why I'm asking. I'm just simply asking for purposes of whether it would be appropriate to make a post-hearing data request to obtain your assessment before the case record closes.
I don't think it'd be terribly complicated. It would involve just redoing a forecast.
And if I may make a on-the-record information request to ask that Kentucky American provide a revised capital structure to reflect the effects of the credit upgrade. And if possible, if Kentucky American would provide with that the Excel spreadsheet for the work papers that support the upgraded capital structure.
That would be fine, Mr. Witcher.
And that's all Commission staff has.
I have one question, if I could. Mr. Rundgren, tell me the difference. Why did you do a rebuttal testimony with respect to your analysis? Was it more than just the passage of time since your original projection and you were looking at interest rates again? Or is that the primary reason?
Well, what happened was, in the initial filing in the case, there was a debt issuance in the base period for November of 2012. And that was really a mistake. It should not have been there, because we knew at the time we filed the case that debt issuance didn't happen. So in the process of updating the capital structure for our update filing on May 15th, I corrected both the base period and the forecast period to accommodate that change in our long-term debt plan. So at that time, since I updated the long-term debt issuance itself, I also updated the long-term debt costs for the planned issuances to go along with that.
And where was the updated long-term debt forecast? I'm looking at in your direct testimony, I'm looking at SWR2, and I'm trying to see if there's an equivalent exhibit to that where your long-term debt forecast would have been updated.
Yes, there should be a, hang on one second. I have a exhibit SWR-3 attached to my rebuttal testimony that has the projected debt issuance interest rates for both the November 2013 and May 2014 planned issuances.
so this is SWR3, is that right?
Right, attached to the rebuttal testimony.
Okay, and so you've got fourth quarter 2013, and is the reoffer spread, I guess I'm lost, in your prior exhibit, you had an estimated spread to Treasury of 2% everywhere. Is the 1.1% equivalent to that?
It's the same, the purpose of it is the same, but the calculations, the value is different because we've observed that American Water debt securities are, the market on the secondary market has gotten better for them, so they're trading at a little lower rate. So the spread between American Water debt and treasuries has narrowed.
Okay, so the interest rates have gone up a bit, but the spread between Treasury and American Water Works
Right.
has narrowed, so the net effect is not that different. Is that a fair?
Now the overall rate came down a little bit.
Is that from roughly, like, for example, in 5.2 something to 4.49 and 4.62?
That's correct.
Okay. And then so, and then how do we get from those numbers to the rate? I think I understand the answer to the question. Okay. Thank you. I appreciate it.
Sure, you're welcome.
This may be a elementary question, but how did the the company get a upgrade on S&P from a double B to an A minus?
Don't recall everything that the report said, but it basically just the financials have improved over time. But we were downgraded by S&P, I believe it was back in 2008, downgraded to triple B plus. And I just think the company has gradually improved over time. They actually improved our outlook to positive, I think last year. Then they finally upgraded us in May of this year. And incidentally, Moody's has also upgraded us to, they have a split rating. Moody's upgraded us from Baa2 up to Baa1, which is a triple B plus equivalent to S&P. So we still have a split rating, but both agencies moved us up one notch.
And the forecast?
That's their credit risk, their credit rating for the company.
Very good.
Mr. Chairman, if we may, with regard to those updates, did Standard & Poor's actually issue a report to American Water? Did they transfer to them a physical document that says this is what we've looked at and you all now get a different grade?
Both S&P and Moody's published reports.
Are those in the public domain?
They published them, yes. Yeah.
Well, what I mean by that is, do you have to be a subscriber to Moody's or Standard & Poor's in order to get access to those reports, or are they just otherwise available to the general public?
I believe I can provide them to you.
Mr. Chairman, if we may, we would like to make that a hearing data request.
So ordered. Questions?
No further questions, sir.
Be direct. Thank you, Mr. Rangan.
Thank you.
Next witness.
The next witness is Carl Myers.
I just sworn. Solemnly swear to tell the truth, the whole truth, and nothing but the truth. Subject to the rules of perjury. Have a seat. Speak loud and clear. Your name, what you do, and why you're here.
My name is Carl Myers. I'm the Director of Corporate Income Tax for American Water Works, the consolidated company. I'm here because Kentucky American filed a rate case.
You witness.
Mr. Myers, did you prepare
and have filed, in this case, what was entitled rebuttal testimony.
Yes, I do.
And was that filed on May 15, 2013?
Yes.
If I were to ask you the same questions in your filed written testimony here today, would your answers to those questions be the same?
For all except for whom I am employed. I'd indicate I was employed by American Waterworks, Inc., but I'm actually employed by American Waterworks Service Company, Inc.
Okay. And is that, so you would make that adjustment to the answer on line 5, page, I think that's the second page of your testimony, correct?
That's correct.
First full page. Other than that correction, with the questions asked in your testimony, would you provide the same answers to those here today?
Yes, they would be.
The witness is available for cross-examination.
Good afternoon, Mr. Myers. David Spinard, and the standard admonition. If you did not hear a question, let me know. If you don't understand it, just tell me, and I'll repeat it and try to work on it a bit. As noted in your rebuttal testimony, you did not file direct testimony in this proceeding. Is that correct?
That's correct.
Now, in the electronic copy, the pages of your rebuttal testimony are not numbered. Are you aware of that fact?
Yes, I am now.
Okay, now, what I want to do for referencing is the rebuttal testimony in the Adobe document is a 192-page document. I'm just going to go off the numbers. Your rebuttal testimony starts 27 of 192, okay?
27? Okay.
Yes, sir, and I want you to go to page 30 of 192 and let me know when you get there. It's at the top of the page, the line 1, there's the answer no.
Okay.
Okay, now just a few basic points. Does accumulated deferred income tax increase or reduce rate base?
Reduces rate base.
Okay. So as the amount of accumulated deferred income tax expense increases, the rate base will decrease.
That's correct.
Okay, now, on line 4 of your rebuttal testimony that's open, there's a statement, ADIT, was accumulated deferred income tax, accounts for the expected future tax consequences of events that have been recognized in the financial statements or tax return. Do you see that? That statement?
What line are you on?
I began with your answer on line 4 that starts with ADIT accounts for the expected future tax consequences of events that have been recognized in the financial statements or tax return.
Okay, my line 4 may be on a different one. It says the ADIT used in the rate case should be the amount able to be sustained by the company.
I don't want to double check because we may be on different pages. Okay. If it would help, I may approach the shop. This is
Oh, okay.
we there?
Yes, I am.
All right.
So what I see ADIT accounts for the expected future tax consequences of events that have been recognized in the financial statements or tax return.
Okay. Now, by reference to the accounting methods for Kentucky American Water Company in place prior to 2008, does Kentucky American Water Company now take tax deductions for some costs that were previously capitalized for tax purposes?
Yes, they do.
Okay. Now, this is, just turn the page.
Okay.
And we're on page 31 of 192. And I'm looking at a question that starts on line 10. Do the guidelines ensure a company records the exact amount of the liability? Do you see that question?
Yes, I do.
And just please read into the record your answer and your rebuttal testimony.
No, but it is the process best determined to present financial statements reasonably and accurately.
Okay. And just turn one more time to the next page, which is 32 of 192.
Okay.
And there's a portion starting at line 14. And it reads, at each reporting date, the company is making its best estimate of its liability to the IRS. Do you see that statement?
Would that be after the Q question why?
Well, the question that I'm looking at on line 11 says, what does the company recommend for this rate case? And then on line 14, there's a short sentence that says the tax law is unclear. That's still your testimony?
Right.
And then I had referenced at each reporting date, the company is making its best estimate of its liability to the IRS. Do you see that?
Yes, I do.
All right. Now, in terms of the best estimate of the liability, in making that estimate, what is Kentucky American Water Company's position on the probability that the deductions that it has taken, such as for its repairs deduction, are proper and will be sustained?
Well, we've determined that that they did not exceed a threshold of more likely than not, which means that FIN 48 prescribes that we have to record them at their net realizable value, which is less than 100% of that position taken on the tax return.
So as I try to translate that a little bit, is there a possibility that the IRS will disallow all or part of the amount for certain deductions?
There's a possibility, yes.
Okay. Now, in terms of FIN 48, what does the FIN 48 amount represent?
The FIN 48 amount represents the amount that we believe will not be sustained under audit.
And with regard to that amount, what is that amount's inclusion? What does that do to ADIT and rate base? How does that all fit together?
Well, we record other long-term liability for the estimated disallowance, and there's a corresponding debit to the accumulated deferred income taxes.
And when you debit accumulated deferred income taxes, does that increase or decrease your rate base?
It increases your rate base.
All right. Now, in your rebuttal testimony, you referenced the Commission's 14 December 2010 order. And this was the order in the prior case, case number 2010-36. Is that sounding familiar?
Yes.
Okay, now, have you read that order from the 2010 case?
Yes, I have.
Okay, and the order, as they always do, it speaks for itself. But on page 20 of that order, there is a statement it's the second sentence of the first full paragraph. And that statement reads, Kentucky American determined that some uncertainty exists regarding the legality of the deduction related to the change in accounting methods. Do you agree or disagree with that statement from the order in case number 2010-36?
I agree.
All right. Mr. Chairman, I have no further questions at this time. Thank you.
Richard?
I have a few. Mr. Myers, let me start off with some basic questions and probably not go beyond basic.
Okay.
First of all, how can the uncertainty of the FIN 48 deferred tax liability be resolved?
It can be resolved either through conclusion of an IRS audit, the statute of limitations could expire, or the tax law could change.
Okay. Has American Water Works Company ever been audited by the IRS?
We have been for tax year 2008.
Okay. That was the last time?
Yes.
Okay. How likely is it that another audit will occur?
It's highly likely.
Highly likely. When you say highly likely, I guess it means more likely than not.
Probably even higher than that. Probably
okay.
75% or higher.
Okay. And in terms of the statute of limitations, what's the period before the statute of limitations run?
Typically, the statute of limitations is 3 years after you file the tax return. Now, in our position, we have net operating loss carry forward, so the statute does not run until that net operating loss carry forward is exhausted. or utilized on a future tax return.
You have to bear with me. I did not do very well in tax law. In terms of this case, does that mean that it has not run yet?
Correct. It has not run yet and won't run within 3 years. It'll be somewhere between 3 and, I'd say, 10 years.
So it would be correct to say that none of the FIN 48 deferred income tax liability has yet passed beyond the statute of limitations period?
The answer is yes to that, but I'd like to caveat that the amount of FIN 48 that's within the accumulated deferred income tax decreases every year. Each layer, we have a layer for every year, and that gets amortized because if it was disallowed, it would be allowed as a depreciation deduction. So therefore, every year, that liability or that asset that was originally set up or debit that was set up in the account will decrease by approximately 4% every year.
Okay, let me come back to that in just a second. Are you aware of any possible federal tax law changes that may occur in the near future that would affect this area?
Yes, there's potentially some guidance specific to the gas industry that may apply to the water industry.
When you say has that guidance been issued?
No, it has not yet.
Okay, and is there an expectation that it will be issued soon?
Soon, by way of the next 3 to 6 months, yes.
Just out of curiosity, how is that does the IRS announce that it intends to go ahead and push out some guidance, or how did you get the 3 to 6 month?
Yes, they have an announcement that they're working on guidance for the gas industry, and they pushed out an expected issuance date. Originally it was June, but that's not going to happen. So they more towards the fall.
In case number 2010-00036, Kentucky American's last rate case, the FIN 48 liability was approximately $2,392,803. Does that sound correct to you?
Sounds correct.
Okay, and in this case, it's $3,922,247.
Yes, that sounds approximately right.
Okay, can you tell us or explain how this liability has grown by $1 million in the 2-year or 3-year period?
It's a percentage of our total deduction that we take. We have to go through a computation where we estimate the probability of success by types of assets that we're expensing. And a percentage of that, not the entire amount, but a percentage of that deduction is then reserved as the FIN 48 reserve.
So has there been a change in the type of assets that would result in a higher FIN 48 reserve?
No, it depends on what was expensed in that year.
Okay.
Each type of asset has a different percentage.
Would it be possible to provide the Commission with a schedule that would list for each year since the American Water Works changed in its interpretation, the annual amount of a liability for that particular year, and then the total accrued liability, and then an item showing the change and stating the reasons for the change?
Sure.
One other thing, could you provide us with how the calculations were done for 1 year so we could kind of work through it?
I would have to check. I don't recall. If
Okay.
not, we could provide you with the computation.
Okay. If council would provide us with that, I believe that's all we have. Thank you.
Some questions. Mr. Myers, let me make sure I understand, probably going even more basic than Mr. Rucher. In December 31st of 2008, American Water Works changed its method of tax accounting, and this was partly the result of that. Is that true?
Yes, that's true.
And what you all did, was that then beginning for the tax year 2009, or was that 2008? you all looked back at these calculations that that you looked back at the expenditures, the expenses, whatever, since 2001.
That's correct, we looked back.
Okay. Was that 2008 or 2009
Was it
tax year?
Well, 2000, it would be 2007 and prior.
Okay. And did you amend returns going back, or did?
No, the IRS allows you to take a cumulative adjustment in 2008.
Okay. So you took a cumulative adjustment in 2008 for all the prior tax years, 2001 through 2007?
Yes.
Okay. And in response to a question by Mr. Wucher, you indicated that the last audit by the IRS was in 2008.
Yes.
Did they, was all that allowed at that particular time, once the audit was done? I mean, did they say that this is acceptable, there's no additional risk, you're blessed?
No, they didn't. They were recommended to not, before this guidance came out, not to look at the issue. So therefore, since they did not look at the computation or look at that issue, it's not considered resolved.
So they didn't look at this issue with the 2008 audit?
Correct.
Okay. Now,
Did the guidance more or less say that they would be audited?
It didn't say that. The announcement coming down from above asked the field auditors not to look into the issue until further guidance was issued.
Okay.
then, so we have the rate case in 2010 where we were looking at all these deductions, if you will, or reservations, and I know I'm not using the right word, that were indicated, and it seems to me that every year that goes by, some of those would drop off. Is that correct?
Yes, some of it would reduce. It would reduce every year. Yes.
But was it? So is it? So for example, in 2010, were we dropping off 2000? For example, 2001, 2002, something like that.
Not full years. A portion, not the entire year. A portion of that year would drop off.
Okay, so now in 2011 and 2012, well, 2013, and this is a test year for 2014. So you're adding new potential liability, and then you're dropping off a portion of the past liability that goes all the way back to 2001.
Yes.
Okay, so some of the 2001 still exists.
Yes.
So it's not a full year dropping off.
No.
Okay, that was my question.
I'm fine.
Let me ask one more question. Is that the reason for the increase of almost $1.5 million? Is that because there were more expenditures made in maintenance that could have been considered in this category that they took in that particular year?
That's correct. If we had more expenditures that qualified as deductible,
Okay.
it would increase that.
And these are repairs that may be either expensed or capitalized. Is that the issue?
Well, prior to 2001, they were capitalized similar to book. And then because of our definition of unit of property, they qualify as repairs under this new accounting method.
Okay, and so there were more repairs. Is this year, are we looking at a forecasted test year for this calculation in this?
Yes, I believe there is a forecast in this computation, in the
Okay, so it's
$3.some million.
so what you're doing is you're looking at forecasted repairs and anticipating an increase in repairs in the forecast test year, and that's the reason for the increase. Okay. Now, do we have a list of what those forecasted repairs are for the test year? No. Okay. If we could have that as, that lead to this $3.9 million. Does that make sense, Lindsay?
Yes.
Okay.
Is that something, Mr. Myers, that can be provided? Okay.
So this is going to, so what, when I see this, I should be able to say, hey, they're going to do this kind of repairs on this or this amount, and that's what this is leading to.
Yes, you should see the type of expenditures, and this qualifies as a repair.
Is it a lump sum, or is it going to be broken down?
It'll be a lump sum.
Who gave you the lump sum? Where did that come from?
We get the amounts. What we have is we do what is, it's a study, and it's an extrapolation. We sample our capital expenditures for the year, and based on that sampling, we do a statistically sample, extrapolate that. That becomes our repairs deduction, and that's accepted by the IRS to use that approach.
Say that again, please.
We do a statistical sampling, so we'll do a sampling of the assets within a year.
Are these the assets that the company
puts in service?
Puts in new assets that they put in service for that year, or existing assets?
No, new for that year.
Okay.
So we'll take a sampling of assets, because we have thousands and thousands of assets we put in service in a year. We take a sampling of that population. We analyze that sample to say what percentage qualified for repairs. That gets extrapolated over the entire population, that percentage. And that's how we calculate our
So your extrapolation does not change the amount. You're just extrapolating a certain percentage based on the amount that are put in service. Now, where do you get the forecasted items that are put in service?
Well, the actual amounts we receive from our utility plant department, the actual department that maintains our fixed assets.
Okay.
The extrapolated number, though, is not really specific to Kentucky American.
It's done, I'd say, company-wide. Every company is consistent.
Would you
Just to
have
add to that, I guess we sample company by company, though. It's not like a broad worldwide sample.
So you
company has-
sample Kentucky American
Yes.
water, and it's a extrapolation of just
yes, of
Kentucky
just its
American.
assets.
But again, just so that I'm clear on this, because I can infer that because the amount of this in the FIN 48 account went up, I can extrapolate that in the forecasted test year, there were more assets being put in service.
No, I just was commenting, even though it's new plant in service, you still have repairs on new plant. Well, you would think that you would have more on older plant in service as opposed to brand-new plant in service.
We look at it every year independent, again, because Books is capitalizing these assets. We look at each year and say, well, were those expenditures qualified as repairs in that year? And if they are, we expense it in that year. Any assets that we determined were capitalizable for tax purposes as well, if repairs are made to those assets in future years, yes, they'll be deductible. I believe that's what you're saying.
Well, I think the Vice Chairman asked you a question, and your response was, it was new plant in service, I thought.
Yeah, well, when I believe there's a little misconception. When I think of new, it's the current year expenditures.
Oh.
So I stand corrected on that.
Yeah, I didn't.
New in the current year,
Thank
not
you.
new
Yeah.
in.
Yes.
Yeah, I didn't understand that. Thank you. Thank you, ma'am.
Redirect?
No, Your Honor.
Nothing, Mr. Chairman.
Your Honor, I have one question. This issue is not merely specific to American Water Works or the water utility industry. Is that correct?
That's correct.
It's applicable, or utilities of various types are facing it. Is that correct?
Yes, not only utilities, but it could be a retailer, it could be a manufacturer.
Okay. Thank you.
Thank you, Mr. Myers.
Thank you.
Appreciate it. Excuse.
Did you want to continue? Okay.
No.
Melissa Schwartz. I'm sorry.
Keep it real short.
I'm not
I'm sorry.
sure. Melissa Schwarzel was our next witness. One of the people that was discussed may be excused, but I think we're all just having questions.
Questions for Ms. Schwarzel?
Mr. Chairman, does not have any questions for these witnesses.
Jerry does.
I do have some. I don't know how long it will take.
Sounds to me like I'm going to have to call it and start in the morning.
Very good.
Thank you all for cooperating. Thank you. We will adjourn for the day, and we'll begin at 9 o'clock sharp in this room. Thank you all.